I don't think I need that. I do have questions for both sides, so I think what I'd prefer to do is simply to ask my questions of each side, one side and then the other, not going back and forth as between Howey test, major questions doctrine, and things of that nature. And then at the end, if there's something I haven't asked you and you believe it's necessary to my decision, you can please let me know. We'll see how that works. For my friends at the front table, is there a division of labor among the issues?
So this is the SEC versus Coinbase, and the hearing is getting started with the judge basically saying, I'm going to ask specific questions.
Mr. Tenrero is major questions. And I'm sorry, who else is speaking, sir? Yes, is speaking about staking and the wallet. Okay, thank you so much. All right, and for my friends at the back table, is there a division of labor?
Yes, Your Honor. Ms., I'll be doing my best to handle questions regarding the investment contract matter, and the case, Howey and others. Ms. Eddy is questions doctrine. Mr. Schwartz, wallet and staking. Mr. Pekin is going to correct all of our errors.
Okay, let's hope there are few, although I of course enjoy hearing from him. All right. Mr. Costello, let me then please begin with you, sir. At the last conference we had in this case, one of the early questions I had addressed the degree to which I could take judicial notice of what ends up being the first 33 pages of Coinbase's answer. It is, of course, footnoted. There are sources to it. What is the Commission's view as to the degree to which I may take judicial notice of the facts that are contained in that section?
Your Honor, I believe that the bulk of the information that you see in those first 33 pages, and I think 105, 106, something like that, footnotes, the information in there is not integral to the pleadings, which is the standard I believe that the court would be following in this instance. On a 12C, the court would be required to accept the allegations in the SEC's complaint as true and would be required to draw all reasonable inferences from those allegations in the SEC's favor, as well as other documents and materials that are contained in the complaint from which we reference. All of that the court can consider, but I don't believe that the same is true for the bulk of the material that you see in those first 30 pages. They're just not integral to the SEC's complaint.
There is a substantial portion of Coinbase's briefing and Coinbase's answer, I guess I'll speak to more specifically, that from my perspective is interesting as a matter of optics, but might not actually be determinative. Just to further probe your answer, if I exclude, and Coinbase will tell me why I shouldn't, the references to, for example, their efforts to either provide information to the Commission or to obtain clarity from the Commission, are you still suggesting that, for example, their discussion of what staking is or what Coinbase's wallet functions as, are you suggesting I can't consider those to the extent that they differ from the way in which the Commission has described these things in their complaint? I would have thought that those things, for example, are in fact integral to the complaint, but I'll hear from you.
I think the easiest way to look at this, Your Honor, is that I think what Coinbase has done in its answer, optics aside, of course, is to just demonstrate why this motion in the context of a 12C is just inappropriate. And when it comes to all of the issues here, be it the investment contract related or be they major questions or, as Your Honor mentioned, the staking program, Coinbase has a very different view of the facts. And that's fine. They can have a different view of the facts, and the SEC views the securities transaction component of this one way, and Coinbase views it a different way. And that is just, I think, more. I think I'm trying to say, Your Honor, that I'm just not sure that a 12C is really the right venue to be resolving that factual dispute. And I think Your Honor had actually may have hinted at this during the pre-motion conference, where just wondering about whether 12C is the right place to be addressing this.
Well, I did, and that's why I'm asking the question again, sir, because I now have a more complete record. I guess the issue is, let's imagine that the Commission has described staking in a manner that runs contrary to everyone else's description of it. The DeFi people, for example, have what I think is a really fine amicus brief explaining to me what the wallet really is and what staking really is. And that actually, in some respects, makes more sense to me than the Commission's description of the complaint. You're suggesting to me that that's a factual dispute I simply can't resolve. Even if, for example, the Commission's description of staking is demonstrably wrong. Yes?
If there is a factual dispute, Your Honor, I would say that the court would not be able to resolve that. But if you look at the two different versions, and there are a number of different points that the amicus parties raised, but if the court is drawing reasonable inferences from the allegations, even though the two different versions of that from two different perspectives may differ, the court would be required to draw those inferences in the SEC's favor at this point, given the nature of the 12C.
Well, related to this question, sir, is the question of the degree to which I can take judicial notice of the factual statements that are contained in the amicus briefs. I'm thinking off the top of my head of the historical presentation given by what I'll call the securities law scholars. I think that's how they refer to themselves. And the background materials, sort of the crypto for dummies that is presented in the DeFi Education Fund brief. Are you suggesting that I can consider those facts except to the extent that they are disputed or somehow controverted by what the Commission alleges?
I think the court could read it as background in considering the legal arguments that are raised. But if it comes to presenting a different version of the facts, that's where I would suggest that the court not consider it, at least not at this stage of the process. If we were to be back here later on summary judgment where there were to be a fuller factual record, then things might be different.
I don't recall the Commission's briefing anywhere, or their pleadings, containing a historical analysis of the antecedents of Howey. Are you suggesting that, to what degree can I consider this information in the absence of contrary information from the Commission?
If the court is asking, can the court look to the different cases that were cited in those briefs, then certainly the court could do that.
Okay, but I mean, it's more than that. They're suggesting to me that if I look at those cases, I'm going to discern a common fact in those, or a common legal position in those cases, and that would inform how I should view what Howey was thinking when Howey was decided. It doesn't sound, or at least you haven't presented in your briefing, an opposing narrative to the foundations, the legal foundations of Howey, or how they progressed from state blue sky laws. And so I just want to know, does that mean you don't dispute what they're saying, or you think that it just doesn't fully answer the question?
No, Your Honor. That is, we are disputing that, and I think that the easiest way to look at this is that if you look at how Howey itself analyzed these cases, the foundational principle that comes out of Howey in this concept of looking at substance of a transaction and disregarding form to focus on the economic reality, that principle of Howey comes from Justice Murphy's review of the blue sky cases. And we have looked at what the securities law scholars have said about these cases, and I'm just not sure that you see a principle coming out of these cases like they say there is, that in the context of these things, an actual contract is required. It factually, and as the posture of those cases showed, they may have involved a contract, but that is different than saying it is a mandate coming from these cases. And I think that's the point that Justice Murphy was trying to get at there, that in discerning what the concept of an investment contract is, the focus is on the economic reality where you are to take the substance to to disregard the form. That is the way they extrapolated the principle from those cases. And I'm just not sure that the court needs to really get into the detail of those cases to see how the Supreme Court itself interpreted them.
Changing topics, sir. As I understand the Commission's complaint, there seems to be 4 Coinbase services that are being challenged. The digital asset spot exchange, the prime service for institutional customers, the Coinbase wallet, and the facilitation of staking. Are those the services, the products that are being challenged in the complaint? Am I missing something is what I'm saying, sir.
No, Your Honor. Your Honor is not missing anything.
Okay. Mr. Chenmuro agrees with you. I'm sorry. He's providing silent commentary to everything, so thank you. And I'm assuming, sir, not to give anything away because I've decided nothing, but I'm assuming that it isn't a binary decision with respect to all 4. I could find, for example, that there's something of concern, at least for going to discovery, with respect to the exchange, but not with respect to the wallet. Correct? I consider each of those individually, although there are some arguments that are common to all.
That's correct, Your Honor.
There are references in the Commission's briefing, and there's I think a footnote somewhere that speaks about the asset hub. And at that moment, it seems that the Commission is also talking about primary offerings in the securities. But I did not understand that to be the meat of the complaint. To what extent are you asking me to look at primary transactions as distinguished from transactions in the secondary market, which is what I understand the exchange and the prime services really pertain to?
As we understand the asset hub feature, Your Honor, we understand that to mean that issuers are able to sell their crypto tokens directly, as Your Honor observed. Coinbase, just judging by the answer that they've interposed, seems to take a different issue as to what features this asset hub actually entails. And so there seems to be a little dispute between the parties, at least as of this point, as to what the asset hub feature is and what it isn't.
Do I need to resolve that dispute for purposes of this motion?
Well, I'm not sure that the court can resolve the dispute for purposes of this motion.
Fair enough. Let me ask the question differently. If I issue a decision that nowhere mentions the term asset hub, have I missed something?
No, Your Honor. If Your Honor denies the motion such that this case continues, then the asset hub obviously will be a point of contention between the two parties going forward.
Sir, as we talk about the principal charges, the Howey-related charges, I want to be sure I understand what is the conduct about which the Commission complains. So can you outline for me, for each of the 4 services provided by Coinbase, precisely what it is that you believe Coinbase is doing as to each that runs afoul of the securities laws?
So, Your Honor, I'll be happy to address the primary claim. I think Your Honor's questions about the staking and the wallet service, I'll defer to my colleague on that one to explain to the court in a little bit more detail. But essentially, the primary claim on the securities front here is Coinbase's exchange, its clearing agency, and its broker service, which my colleague will address in a moment. But just looking at the exchange and the clearing agency service, what we contend is that there are securities transactions that are taking place on Coinbase's platform. And Coinbase disputes that, and you know that is what it is. But in our view, the securities transactions are taking place, which would mean that Coinbase is currently operating as an unregistered exchange and an unregistered clearing agency. An exchange in the sense that a marketplace for bringing together orders of buyers and sellers, as the Exchange Act defines what an exchange is, and a clearing agency in the sense of settling transactions, ensuring that the transaction goes from buyer to seller, and that also is defined by statute. And our complaint takes through each of the elements of that, but it's essentially Coinbase's intermediation services in that sense that are at issue.
And the answer you've just given me is principally focused on the exchange and the prime services, yes?
Correct.
Okay. In your brief, in your complaint, you make a point of saying, or you make a point of suggesting that there is some novelty to combining exchange and broker and clearing services. I'd like to understand that a little bit more. I believe that Coinbase disagrees with you and says it's not that big a deal, but you've made mention of the uniqueness of it. I'd like to understand why I should care.
So typically, Your Honor, you do not see those three functions, exchange, clearing agency, and broker, combined under one roof, so to speak. And the reason that you don't see that is because of a number of potential problems that poses. For example, if you look at a properly regulated and licensed exchange, the members on that exchange are the broker-dealers. If you have an exchange itself that is also performing a broker function, that presents the potential for a conflict of interest in terms of when broker-dealer orders are placed, the exchange might be tempted to place its own broker-dealer function ahead of the orders of the other brokers. In another sense, it presents another conflict in the sense that the exchange might be prone to using the confidential customer information from these other broker-dealers to its competitive advantage over the brokers.
Right. And neither of these is alleged in the complaint, though, correct?
No, that is not alleged in the complaint, but
okay.
That is so that the court understands why these functions are normally not combined under one roof.
Fair enough. And I appreciate you. Let me try and sharpen my question then. You've just indicated to me that there are reasons why you'd want to not combine those functions, and I appreciate some of the reasons that you've given, and I'm sure there are others. How does the combination of those functions, as alleged here, impact your claims of violation of the securities laws?
The separation of the functions, or I should say the failure...
And actually, can we just pause for a moment off the record?
What?
Coffee? Oh, not in the courtroom. Thank you. Back on the record. Please
No
continue.
coffee?
So, Your Honor, the issue here is not that those functions are combined, because there's nothing per se illegal about combining the functions. But the fact is that the Commission has never registered an entity that has those combined functions. The issue here is if
Sorry, could you say that again, please? The Commission has or has not registered an entity that combines those functions.
So the Commission has never registered an entity that has a combined exchange and clearing agency function. It has also never registered an agency that has an exchange broker-dealer combination function. But again, there is not anything per se illegal about it. But that is not really the gist of what our claim is here. Our claim is not that they've combined these functions. Our claim is that there are securities transactions taking place on Coinbase's platform. And because there are, Coinbase, in acting as an unregistered exchange, has violated the securities laws. And Coinbase, acting as a clearing agency, has violated the securities laws as well.
It's a logical extension of your argument, the argument that the 12 or 13 issuers, depending on whether you count Nexo, N-E-X-O, that they're all violating the securities laws as well, because they're issuing securities that are not registered. Do I understand that? I mean, I understand they're not in the complaint before me, but I'm assuming if what you're arguing is that Coinbase is somehow, by providing these intermediation services, violating the securities laws, that the actual token issuers are themselves violating the securities laws. Is that correct?
Well, not exactly, Your Honor.
Okay.
Because if we look at the platform itself, you were talking about, and Your Honor observed earlier that the bulk of our complaint is directed towards secondary market trading. And so if you look at the secondary market resale of a token, the seller of that digital token is not the issuer at that point. It is a private party who is actually the offeror or seller. Every sale of a security has to be either registered or exempt. But what you are going to see here is that the bulk, that 9 out of 10 sales in this context are not going to trigger the registration requirement between, a private seller and a private buyer, because Section 4 of the Securities Act provides exemptions from registration, and one of the most common exemptions is what we call the 4A1 exemption, which exempts all offers or sales other than by an issuer, an underwriter, or a dealer. So these private party resales that you see taking place, that is not going to trigger a violation of the securities laws in the sense of registration.
Well, what about the initial offerings of the tokens? When the issuers decided to issue these tokens, a SOL or SOL, for example, do you believe they were issuing securities?
If yes, Your Honor, yes, we were, and if those transactions were not registered, then yes, or exempt, I should say.
I'll ask the question just to make sure I understand this better. I appreciate that earlier I asked you to whether we were focusing on primary or secondary transactions, and I appreciate your answer on that. You're saying that as to these 12 or 13 tokens, when they were initially issued, these tokens were themselves securities.
Yes, Your Honor.
Okay. I understand the argument. I appreciate that. We're not claiming that Coinbase is the issuer. You said they provided intermediation services. I've heard them in their capacity as a broker, in their capacity as a settler of trades. Are you arguing that they're a promoter in any respect?
A promoter of the offer or sale, not in the traditional sense of what you would call promotion.
Okay.
So no. For example, Your Honor may have seen in some of the Howey cases the concept of a promoter.
That's what I'm thinking of, sir.
Correct, Your Honor. No, not in that context, no.
And so from your perspective, the liability inheres in the fact that they are a third party whose conduct can impact the value of the token, or is it that they are what's the third party that I care about here? The Howey test speaks to it. So what is the third? Is it the actions of the issuers themselves, the actions of individuals in the orbit of the issuers, or the actions of Coinbase? What am I focusing on?
The focus is going to be on the actions of the issuer, and the developer and the project team together. So what you would call the issuer, just for if you want to lump them all together as one category, and that is the focus because the issuer is in charge of maintaining and expanding the network that surrounds this digital token. And I think it's important for the court to understand that the practical application of this, because at the end of the day, these 12 or 13 tokens, they're just computer code, okay? Those tokens are linked.
I'm smiling, sir, because that's kind of what your friends at the back table are saying, and they're wondering why we're here.
And,
so okay, yes.
And I promise, Your Honor, I will get you there. So it is just computer code, and the computer code is linked on a blockchain, because it's a bunch of letters and numbers that live on that blockchain. But the key here is that these letters and numbers from this code go with that blockchain and its surrounding network or ecosystem. You'll see sometimes the case is used. And it's that network or ecosystem that is what drives the value of the token, because the token as code is linked to that ecosystem. It is tied to it. It cannot be separated from it. As the value of that network or platform or ecosystem increases, so does the value of the token. And the issuers and the project team, they drive the value of the ecosystem. So your token, being part of this ecosystem, is going up or down in value based entirely on what these issuers and project team members are doing and continuing to do. So it is their conduct that would be relevant for the Howey analysis. The way Coinbase fits into this is, aside from facilitating, or I should say intermediating the transaction by serving as the exchange for this, Coinbase is also rebroadcasting all of this by linking to all of the material of the issuer and the project team right there on the platform. When a customer opens an account on Coinbase and wants to look at different tokens to purchase and sees one of these 13 in particular as example, they can click on it and they can be linked right there to all of this information, including the value proposition for these tokens based on what these issuers and project team members are doing. So the focus...
Okay, but please pause. What if Coinbase didn't include that information? You refer to it as broadcasting, they refer to it as simply the provision of historical information. Had they not done that, would you still believe these intermediation services to bring them within the securities laws, and if so, on what basis?
Yes, the answer is yes, and the basis is because regardless of whether or not Coinbase is rebroadcasting it, that doesn't change the calculus of what these issuers and these ecosystems are. All we're saying is that Coinbase rebroadcasts and amplifies it right there on the platform, that even if they didn't, that wouldn't change the analysis.
Okay, and so therefore the fact that it's simply their placement of these assets on their platform, by dint of the fact that, in your view, the assets themselves are securities. The placement of these securities on their platform, either the spot or the prime, that's enough. I mean, it's gravy as far as you're concerned that they also provide information, and I suppose you'd say it's even more interesting that there are efforts made to improve or to enhance or to develop their own customer base by having them purchase these assets. But if we're looking at that irreducible minimum of conduct that brings them, you believe, within the ambit of the securities laws, it's the placement on their platform of tokens that you believe to be securities.
Yes, Your Honor, but let me just clarify, though.
Please.
The token itself is not the security.
I understand that, right, and that's what, was it Mr. Hinman or someone else who said that? Someone from your shop who's no longer there had said that, so yes. Token alone, not a security. So tell me what makes these the securities.
So this goes to what I said before about
the ecosystem?
About what it is that someone is buying when they purchase the particular tokens like this, like these 13 examples. When they buy this token, they are investing into the network behind it. One cannot be separated from the other. One is the other effectively. And when they are investing in this, when the value of the network or the ecosystem increases, so does the value of the token. That is the way that Judge Rakoff looked at it recently in the Terraform decision, noting that it is the token essentially plus the totality of the inducements about what makes the ecosystem. That is what translates this to here. And when it comes to Coinbase's conduct, the fact is that because they meet the definition of an exchange, and I don't think that they are debating in this case that they otherwise meet the definition of an exchange, and they meet the definition of a clearing agency based on the types of services and functions that they do. I think the dispute here is that they are a securities exchange and a securities clearing agency, because those statutory provisions would only be triggered if there are securities transactions taking place. That, I think, is the dispute between the parties here. But Coinbase's conduct would be if purchases and sales of these tokens, these transactions, these investments into these networks, if the court finds those to be securities transactions, then by definition Coinbase is operating as an unregistered exchange.
I suspect that I might have broader questions on this issue in a little while for you, but I am interested in the first instance about your argument to me just now that the token alone is not a security, but that the person buying the token is buying into a system. You've referred to it earlier as an ecosystem. How do I know, or how have you made the determination that a particular token brings, the purchase of a particular token, brings with its entree into a system as distinguished from just having an asset that is not a security. I'm trying to figure out what about these particular tokens allow you to make the argument that their purchase is not just the purchase of an asset, but the purchase into a system that implicates the securities laws.
Sure, Your Honor. I think the easiest answer to that question is that transactions in these particular 13 tokens satisfy the Howey test. That's what makes them security.
That's a little bit circular to me, sir, so we'll try that again. You're saying to me that if I were to go onto Coinbase right now, and if I were to set up an account, that I can get any number of assets that, in the Commission's estimation, are not securities, correct?
I just want to clarify something, Your Honor.
Please.
What we've done in this case is we have pointed out 13 examples of digital tokens where we believe investment contract securities are taking place. We have not looked at all of the tokens that are trading on Coinbase's platform, but as I think we had mentioned at the pre-motion conference, it would be sufficient for the court to find that just one token is a securities transaction. We have pointed out 13 where the Commission has made the determination that it believes that these transactions in these 13 tokens are securities transactions.
I did understand that, and I did not think that by citing these 12 or 13, you were excluding all of the others. What I'm trying to figure out is, what is it about the issuance of these tokens? What is it about these tokens that brings them within Howey? And for you to say, well, they satisfy Howey, is not a helpful answer to me. For example, there's a fair amount of description in your complaint about what the issuers were intending to do, what statements they've made, what it is about that, whether, for example, these tokens are promoted and geared towards either advancing the blockchain or the goals of the blockchain or developing apps for the blockchain. So that's what I'm trying to figure out. You're acknowledging, I think, the theoretical possibility that there is stuff on Coinbase, there are assets that are not securities. I understand that you've identified these 12 or 13 that are. What is it about them? And please don't say Howey. What is it about them that you believe makes them securities? Thank you.
Understood, Your Honor, and I apologized earlier. I misunderstood.
I wasn't asking a precise enough question. I hope I did now.
So I think maybe it would be helpful if we looked at one or two tokens in particular, so we can kind of illustrate the point about what we think is making these investments. Because at the end of the day, that's what this is. It's an investment, and essentially the investment depends entirely on the efforts of other people to bring value to that investment. So if we look at the Chili token, for example, that's the CHZ token. That's a sports and entertainment platform. And if you look at how we track through the development of this, you see in a lot of these instances, these token issuances come about when the blockchain and the network first launches. And to do that, these issuers and project teams need startup capital. So they will sell a certain amount of tokens to institutional type investors to get the development capital that they need to launch the blockchain. And that can be done, and this is not just for the Chili, but this is for all of them. And it can be done in a combination of direct placements, initial exchange offering, and SAFT agreements, simple agreements for future tokens, where the institutional investor will get the right to a certain amount of tokens after launch. Oh, I'm sorry, am I speaking too fast? I apologize. And so they set this up, and then what they do with that capital is they then launch the blockchain, they launch the network, and then they continue to expand and add value to it. Now, how does that play out in real practice? Well, if you look at Chili, so the Chili, the original white paper and its website feature biographies of the founders and their project team, highlighting their past managerial and entrepreneurial background. They then explain how they allocated certain percentages in those initial formation that I was talking about earlier. The Chili issuer had allocated certain percentages of those of the Chili token to the founders and the project team to show essentially that these individuals, these founders, these developers have ongoing vested interest in this enterprise at the end of the day. They own tokens as well, and it's to their advantage to do whatever they can to improve upon and expand this value, because when they do that, they benefit too. Now, in 2018, 3 years before Chile was listed on Coinbase's platform for trading, Chile released another white paper stating that they are no longer looking to fundraise at this point. They are now looking to focus on leveraging resources to realize what they call their vision for the ecosystem. Then the team has also stated publicly that as they are able to grow the platform and partner with more of these digital sports teams, because it's a sports and entertainment platform, as they're able to partner with more of these teams, the value, and this is where this comes into play, the value of the token will increase. In fact, in one tweet that they sent out, it's quote, "Demand for CHZ exploded, going to bring a lot of value." And they also made efforts to drive secondary market trading by burning, and that's a term for creating scarcity in the tokens to make them more valuable. So if you look at that as an example, and the various tokens, they all follow essentially the same initial track of that developmental capital that starts it out, and then it expands beyond that. But this is just an example to show you that this is the way that these issuers and these developers are looking at the tokens and the networks, the ecosystem themselves. They are looking at it as value proposition. And then they are broadcasting this information publicly so that demand is going to increase. And that is the way that we have characterized the allegations in this complaint, because at the end of the day, when it comes to applying Howey, it is an objective test. It's principles-based. It looks at all the facts and circumstances. And we view transactions in these particular tokens as presenting as value propositions. As Judge Rakoff noted, when you purchase this token, you invest in that platform.
And do you mean that at both the developmental stage and the expansion stage, or to you, did those stages, is one set of tokens at one particular stage not a security, and later sets is a security? By the way you're describing CHZ, it would seem that they were always thinking about how to enhance the value of the CHZ token, and therefore both the initial, the developmental offering, and the advance and expand offering are both, the tokens that resulted there are both securities in your conception of things, which I understand folks at the back table disagree with. Is that what you're saying?
Yes, Your Honor. We're saying that it doesn't make a difference whether you have it initially or whether you get it secondarily. And this actually highlights, I think, one of the major disputes between the parties, because the question becomes, if you have an investment contract that can be created when you buy something, when you buy one of these tokens from the issuer, that Coinbase seems to think that you can't then trade that in the secondary market. And this is where both sides part company a little bit. But we think that if the court looks at this, again, for what these items are, this is a digital token. It is computer code that links to a blockchain. Whether Your Honor is the first person to buy this particular token from this particular computer code, or whether Your Honor then sells it to me and then I sell it to Mr. Tenrero, it is the same computer code no matter which one of us has it. It's still the same value proposition.
And so this is where you're disagreeing with Judge Torres in the Ripple case.
Correct, Your Honor. And the reason that we respectfully disagree with Judge Torres is because when you have those programmatic, those were the retail purchasers, when they are buying XRP, they're buying the same XRP token that the institutional buyers are buying. It doesn't matter whether they buy that from Ripple or from the secondary seller. It doesn't matter. It's the same token. in the same ecosystem. There's no need to create two different categories of purchasers in that sense. And there's no need to do that here either. We just think if the court looks at the reality of what the transactions are in, being these digital tokens, being computer code, it doesn't matter who possesses it. It's still the same investment in the same thing.
In the Commission's review of the tokens that are offered on Coinbase, and I appreciate that I'm asking you now, but something you didn't allege, did you find tokens that are there that someone could buy for sport? I mean, for no appreciation? I'm just trying to figure. I would have thought that everybody buying a token on Coinbase hopes one day that token will appreciate in value. But perhaps you've seen tokens that where there was no ecosystem. And if so, if it's possible, could you give me an example of one of those where you looked at it and said, this does not qualify?
I believe that the Commission has taken the position that the Bitcoin token is not a security. I think that is, and I believe that you can purchase Bitcoin on Coinbase's platform.
Is that because it's effectively currency? It's a replacement for fiat currency or something else?
I think that the way to look at that is, again, to come back to Your Honor's question about the ecosystem, there's no ecosystem behind it, and I think that's the easiest way to look at it, because the way we view these 13 particular tokens is that you're buying the token and the totality of the inducements. If nobody is inducing anything, then you can't be buying that in a sense, and I think that you'll see in instances like Bitcoin, it lacks that centralized function. Now, with respect to the others, as I said, I don't know that we've analyzed all of the tokens on there. I think we've looked at just these particular 13. Now, it's possible, even with these 13, I don't know if I'm sensing Your Honor's next question or not, but
I doubt it.
When people purchase these 13 tokens, is it possible that some people are buying these particular 13 for utility, to use instead of to invest? That is possible, but that's not the way to look at it.
Well, I guess it's possible. I thought your argument would be, which is why it wasn't my next question, was that you've alleged that at least someone out there is buying for an appreciation of value, and I have to accept that at this stage. So the fact that there might be someone who just likes the name or thinks that there's something about the issuer that's cool for them, that I get that. I get that there are people who are not buying. I'm imagining that somewhere out there's someone with more money than brains who's buying just to buy, but that's not what you're alleging in the complaint, and I'm accepting your allegations, which is why I didn't ask that question. Let me please do this. I'm going to give you a break. I have many more questions to ask, but I think I'm going to turn to Mr. Margita for a moment, because I want to have sort of an intermission to talk about the staking and the wallet programs. Sir, again, I found very interesting the DeFi education organizations, Amicus, in this regard. Are they wrong in their description of what the wallet is? Are they wrong in their description of what staking is? Or if you'd like me to ask the question differently, can I accept their factual statements about how these things operate?
Well, Your Honor, I can answer it two ways. One, I think they are wrong, but I think the more relevant point is what my colleague, Mr. Costello, referred to earlier, which is I think Coinbase and DeFi Education Fund get it wrong, but you don't need to consider it at this stage of the litigation, because what you're talking about is Congress defined broker broadly in the Exchange Act, but we have this judicial test. Both parties have briefed that, so I'm not going to go over it, but you're talking about the application of a 9-factor test where the parties have factual disputes about the extent to which Coinbase acts as a broker through its wallet application. So I think what the DeFi Education Fund and Coinbase are doing is minimizing the function and the substance of what wallet is and does, by emphasizing that it provides, that it's run through software, that it provides a technical interface. But at its core, what wallet does, Coinbase, acting as a broker, actively solicits investors for its wallet program. the investors download the app, and the app, even though it only takes a couple seconds, what Wallet does is significant. So Coinbase in its briefing talks about going to a store and you pull cash out of your wallet. It's just like that. That's wrong. You or I or any retail investor cannot, like going into a 7-Eleven to buy a big gulp, you can do that. You don't need a wallet to do it. You can take $20 and $3 and buy a big gulp. To access and engage in the securities transactions on wallet, Coinbase is essential. I don't have a relationship with DEXs out in the crypto universe. I can't pick up a phone and make my own connection with them. Coinbase provides that for its investors. The swap feature that Coinbase markets as part of its wallet feature is instructive. What the swap feature does is I'm a wallet user. I log onto the app. I want to trade one crypto asset or another. Coinbase, through its wallet application, will access liquidity in the DEX market. It has relationships and establishes connections with dozens of DEXs. It will go out and find a DEX that will satisfy the asset I want at the quantity I want to find that liquidity. It will compare prices across the DEXs that satisfy the liquidity request. It will do all of this in seconds. It will then present, and this isn't pleaded, but we define swap in the complaint, Your Honor, and at page 27 of our opposition, we cite Coinbase's website, which defines the swap or the trade as using the protocol within the DEX aggregator and the OX protocol to go out and to compare prices for that liquidity and find the best price, present it as a proposal to the user to either accept or not. That is not just a technical interface. That is providing brokerage functions, soliciting investors, routing orders, providing advice in the form of a proposed swap. That is essentially, it actually goes farther than what Vanguard or E-Trade would do. Nobody claims that Vanguard or E-Trade isn't an online brokerage because they provide automated tools for users to effect and participate in securities transactions. So I think Coinbase and the DeFi Education Fund, they are wrong in the sense that they're minimizing the function and effect and substance while waving around the fact that it's technology. I think that's a red herring, Your Honor.
Is it similarly a red herring in your estimation that Coinbase hasn't taken a fee for the wallet service since April of 2023? Do you believe that if we were just to think about the wallet function today, is the fact that Coinbase is not today charging anything for it make it any less or implicate any less the securities laws?
No, Your Honor. The Commission is entitled to bring enforcement actions for historical and ongoing violations. We've essentially brought them.
No, I'm sorry. I appreciate. I'll ask a better question.
Okay, Your Honor.
When they were charging a fee for wallet, it was easier for you to say that there's somehow some violation because not only are they performing these services that you believe transcend a technical interface, but they're charging something for it. Right now, today, they're not charging something for it. Is it still violative, or does it still implicate the securities laws? And if so, what specific part of wallet implicates the securities laws?
Okay, Your Honor. It is, putting aside the transaction-based compensation, it is still a violation. Gel Direct and Hansen and other cases tell us that there are multiple factors, of which transaction-based compensation is one, but not a mandatory or required one. We have alleged several other factors in our complaint, including active solicitation of investors, the routing of orders, and the giving of advice for the reasons that I identified in my prior answer, Your Honor.
All right, thank you. One moment, please. Let's then turn to staking. You or one of your colleagues at our last oral argument expressed surprise that that Coinbase was moving to dismiss the staking claim. To whoever the oralist was, their view was that actually staking was the strongest of or a strong claim by the Commission, who might have prioritized. maybe. I found staking to be the least traditional investment-like of the functions that you were complaining about here. So I'd like to understand what it is about that. What is it that Coinbase does in the staking context that brings them within the ambit of the securities laws? For instance, the validation protocol that is inherent in staking, that's not like normal investing. I don't think of it as such. And I thought your argument was that it was the aggregation or the pooling of tokens in order to perhaps make a particular group of stakers more interesting to the folks who are using them to validate these transactions. That's what Coinbase did. But perhaps I'm wrong. What is it in the staking context that Coinbase is doing that brings them within the ambit of the securities laws?
Okay, Your Honor. Yeah, I understand what you're saying about validation services. I think what Coinbase is doing is taking an established technology and building an enterprise on top of it. I think Edwards and Rivera are good examples of that, where payphones exist, and ETS, the promoter in Edwards, says, we're going to create an investment program based on that. And we're going to use our technical expertise. We're going to install the payphones, maintain them, repair them, collect the coins, and distribute investment returns. That's essentially what's happening here. Investors are giving up their crypto assets to Coinbase's control. They are pooled, and then Coinbase is using its managerial efforts to manage the enterprise, which is the Coinbase staking program. They provide all the infrastructure, they retain third parties, they operate the validators to ensure greater odds of success so that investors will actually earn the rewards that Coinbase is marketing.
So you just said they operate the validators? May I understand what you mean by that?
They operate the validators at the nodes of the respective blockchain protocols. And so here again, not unlike with Wallet, Your Honor, Coinbase is saying essentially that because its efforts are technical, they cannot therefore be managerial or entrepreneurial, and the case law does not support that.
Well, I mean, you're both fighting over what is ministerial and what is managerial. So one of the reasons I'm asking you what it is Coinbase is doing is to figure out what it is you're upset about. But the second thing is what the things that you're describing them as doing. I want to know, do you define all of those as managerial, as distinguished from ministerial? I suspect as well that this is another case where you're going to tell me that irrespective of all the briefing on the issue and the differing conceptions, that differing conception simply means that at this stage of the game, I can't dismiss the claim.
I do want to say that, Your Honor, but I won't, because I think you just made the point.
Well, I did, but I just want to, again, this section of our argument is for me to understand what precisely Coinbase is doing that you're upset about. And particularly as to staking and wallet, where there is such a divergence between the parties as to what acts Coinbase is doing, what it is you think they're doing.
Yeah, Your Honor, that's a fair question. I just want to bring it back to Howey compels us, and its principal faith compels us to look at the economic reality of whether investors are giving up their capital and pooling that capital with the promoter's efforts. That's exactly what's being done here. And Coinbase's arguments, and I understand they disagree with the Commission's allegations, they are elevating impermissibly, in our view, form over substance. What Coinbase is offering and what they have marketed is that you can put your assets to work, not to validate transactions or provide some other consumptive use, but to earn returns on your investment. Give up their funds, Coinbase pools them and uses them through their, managerial efforts. And the case law does not support Coinbase's view. I understand Coinbase now is pulling back on everything it marketed that its staking program would do. Staking on your own is complicated and costly, they said. Coinbase will do all of that for you. That is an investment
right,
contract.
right? I mean, they're
Absolutely.
right. Okay.
There are economic barriers that prevent certain people from doing exactly what Coinbase is providing. Same thing in Gary Plastic. There's an underlying bank issuing a CD, and Merrill Lynch creates an investment program where it undertakes efforts to promote the program and create a secondary market. And then Edwards and Rivera, which I've mentioned also, provide potentially seemingly ministerial things, but they are managerial efforts in furtherance of the enterprise, requiring no efforts from the investor to generate the returns that they marketed. That is, under Howey, an investment contract. That is the economic reality, as we've alleged, of what's happening here.
Well, I guess I have two follow-ups to that, and the first is whether the parties are in agreement as to the specific services that Coinbase is providing, and then secondly, whether one can fairly denote those services as ministerial or managerial. I guess among these issues, there are claims by Coinbase that the investors never actually lose their assets, that they're always retaining custody. And I think in this regard, to me, it sounded, for example, and I realize this is very low tech, but I have money in a savings account, right? You can use my money in the savings account. You can do something with it. I presume the bank is doing something with it, but I get interest on that. Why is staking akin to interest payments on a bank account? And are you telling me it's not because, for example, I'm never going to lose my bank account, and here one could, in certain highly unlikely but nonetheless identifiable circumstances, lose the asset? Because, again, there are two things that they're saying. They're saying the asset holder does not give up its ownership of the asset, and they say there's no real risk of loss. Are you disagreeing with them? Are you suggesting that there's a disagreement that however it works out, I can't decide it at this stage, or something else?
Well, I'm disagreeing with them, Your Honor, in that giving up legal ownership is not required. SEC v. Edwards tells us that. The investors who purchased the payphones that were essential to the enterprise were promised a refund of their capital. The Coinbase's citation to its user agreement about owners do not give up investors do not give up legal ownership, it's just irrelevant. And there are risks, and Coinbase tries to, and we put this in the brief, Your Honor, so I won't go into it too much, but Coinbase is reading into the investment of money prong of Howey requirements that simply do not exist. If there is a risk that is inherent to the enterprise, like a cybersecurity incident or theft or loss of private keys or Coinbase failed, that risk matters. Same thing with flashing, which is a Coinbase-specific risk.
Sure, but hang on. The likelihood of slashing happening is really small. But the fact that it could happen is enough? Is that your argument?
Well, Coinbase admits in its answer that it could happen. It just says it hasn't happened, and we provide a limited indemnity. But
Yeah.
the risk exists, and that's enough.
What if they had a full indemnity? Is that no longer an issue then? Have you lost that argument?
No, it's still an issue under Edwards because they are guaranteed their money back. Gary Plastic is a good case, Your Honor, because it shows the risk, as the Second Circuit noted, is you could have the underlying bank, the issuing bank of the CD, go under. But you could also have Merrill Lynch go under and not do what it promised to do as part of the enterprise. All of those risks matter, and so Coinbase's attempt to identify and distinguish between Coinbase risk versus non-Coinbase risk or staking risk versus non-staking risk is irrelevant.
Well, you've answered my next question, which is I believe Coinbase suggests that the risk needs to be a staking-specific risk because they suggest, for example, that certain things could happen whether you solo stake or stake through their program. Certain things could happen if you're just a customer of Coinbase and not a member of the staking program. And there is a suggestion that there ought to be something more, something staking-specific. You're telling me that under Edwards, in cases like Edwards, there is no act-specific risk of loss that has to take place. In this case, a staking-specific risk of loss that has to be identified.
That's right, Your Honor. And I think Gary Plastic respectfully washes away that argument because of the risk I identified. The underlying bank could go under, Merrill Lynch could go under, and all of that affects whether investor assets are put at risk as part of the enterprise.
Just moving back a moment, sir, to my first question, which I may have the answers to, but I want to make sure I do. What is the staking conduct that Coinbase does? I want it in gory detail. What is it that they're doing that you believe brings them within the ambit of the securities laws in a specific context of staking?
Okay. with respect to the efforts that they market and that they undertake to further the enterprise?
Yes.
Is that what you're asking? Okay. So Coinbase sets up the infrastructure with each of the 5 blockchain staking protocols. They retain third parties to actually carry out some of the staking, although, as I mentioned earlier, Coinbase operates its own validators as well. It provides for increased server uptime, which is important because Coinbase, as we allege, pools investor assets along with Coinbase's own assets and stakes them at validator nodes. And that increases the odds that Coinbase will be selected to validate transactions on that protocol and thereby increases odds of success of the enterprise. Once Coinbase is selected, or a third party that it retains, the validation needs to occur in a timely manner, and that's where the slashing risk comes into play. Coinbase provides maximum server uptime to allow for greater odds of success. Then, when the returns are paid out, and all the while investor assets are staked at the protocol during what's called a bonding period, investor assets are not able to be pulled out. Once upon a time they were as a result of Coinbase's liquidity pools, but apparently they no longer use those. And then returns, Coinbase pays itself, and then it distributes investor returns on a pro rata basis to investors.
How long does that bonding period last?
I believe it depends on which protocol you're talking about.
But is it a matter of minutes, seconds,
I
days?
believe days and weeks.
Days and weeks, thank you. Okay.
It's quiet.
Coinbase has argued that rewards that are set for stakers are set by the individual blockchain protocol and not by Coinbase. Do you disagree with that? Does it matter to my analysis? I sense you're going to tell me that even if that's true, it doesn't detract from all these other things you've just listed for me. But let me have you actually answer the question.
That's right. And to go back to Gary Plastic, the issuing banks and CDs set the rates. It's immaterial. What Coinbase is doing is creating on a larger scale an opportunity to profit off of the staking infrastructure. For some of the reasons I identified earlier, Coinbase's efforts make it more likely that investors will receive returns because of the maximum server uptime and because more assets are able to be pooled and staked at the validator nodes. That's what's more relevant, in my opinion, Your Honor.
A moment, please, sir.
I'm throwing a summary on ehack.com, by the way.
Back to Mr. Costello. I thank you very much, Mr. Costello. I know you're rested and ready to go forward. We are back to Howey, sir. And as you know from reading Coinbase's arguments, the argument that they're making is that an economic arrangement can qualify as an investment contract only if it involves an ongoing business enterprise where management owes some sort of obligation, I think an enforceable obligation to investors. I think as well, in a later stage of their briefing, they suggest that the investment must implicate a claim on the proceeds of the business rather than on the thing that the business creates. In the alternative, that's what they say, you're going after just asset sales. Now, I appreciate that you're taking a different view, and that's why we have this case. But just again, looking at what the limits of your arguments are you taking the position that the purchasers on through Prime or through the spot exchange of these 12 or 13 tokens would have, if they wanted to, one of the traditional private rights of action under the securities laws? For example, if I bought Sol and decided that I don't want to cast aspersions on them. Let's say I bought something that was not one of your 13, but that is just was just rife with fraud. Like there's something to that in Terraform, I suppose. But if I did that, what's my recourse as a purchaser? Are you suggesting that by bringing this action, you are by extension enshrining the idea that crypto asset purchasers of at least of these 12 or 13 can bring 10b5 actions? Or I suppose, actions under the 33 Act for selling unregistered securities.
I think what we're contending, Your Honor, is that when we're talking about contractual obligations beyond the point of sale, I thought that was Coinbase's original position that they took in their briefing, at least in their initial brief. And then in their reply brief, they appear to have refined that somewhat. They appear to be saying it's now the impression of a contractual undertaking, and I'll address that in a moment. But just on this concept of this contractual obligation, what they're essentially looking at, as Your Honor observed, is the question of enforceability in a way. In other words, being able to compel the issuer, for example, of the SOL token, to compel the issuer to actually do something. If the issuer has said, I'm going to expand this network and add a whole bunch of new DApps and features, and if that's not done, then what would the purchaser be able to do about it? And the question is, whatever the purchaser can do about it has nothing to do with whether a security is present. And this issue surfaced in Joyner, which was a long time ago, and the Supreme Court in Joyner looked at this and said that whether or not a purchaser of the leasehold interest could actually compel the defendant to drill the test well, which was the central feature of what made that an investment contract, that was the inducement. And the fact that the purchaser could not, whether or not the purchaser could compel the defendant to drill the test well, was what the Supreme Court said a question of state law that we, quote, find unnecessary to determine. Reason being, whether or not it's enforceable has nothing to do with whether a security is present, is the point. And I think that's what Coinbase overlooks with this argument, which I'm not sure if that's why they changed the argument in their reply to talk about an impression of a contractual undertaking. I'm not sure I know exactly what an impression of a contractual undertaking is.
Let me explain my concern. Let's say I agree with you that certain of these tokens, at least one of these tokens, is in fact a security such that having these things placed on the exchange or transacted through the prime service would amount to operating an unregistered exchange. My concern is, does that mean that every crypto asset purchaser of those 12 or 13 securities can, if they decide they don't like what's happened, bring some sort of fraud action? I am being selfish about my thoughts here. I don't know that I really want to have that MDL. So I'm trying to figure out what is the... You telling me whether enforceable doesn't mean it's a security. Okay, fine. But I actually care about how you're defining security because I want to understand how, not only how it applies in this case, but what it's going to mean to individual purchasers of these crypto assets going forward. And so you'll understand that one of my concerns in this section of our questioning concerns what are the limits? Are there limits? Are there some guardrails in the Commission's arguments? Because I am concerned, and several of the amici have suggested I should be concerned, that what you're asking for is too broad a definition of what constitutes a security. So I'm back to my original question, which is, what does my finding in your favor mean for the purchasers of these 12 or 13 tokens?
Your finding in that sense, Your Honor, would mean that the purchaser of the particular 12 or 13 tokens has purchased a security as in the form of an investment contract. That would be the conclusion. And in terms of what that means significantly, well, if it is a security, then it is a security. Now, there have to be a whole host of other things extraneous to this case that kind of come into play there as to what to do about it.
Of course, and I'm not suggesting that any or all of the token issuers are engaged in any way in fraudulent activity, but if you find, for example, that these are unregistered securities, I would think that in the first instance the asset purchasers would have a right of rescission. Am I mistaken about that?
They would under
Okay.
Section 12. They can seek precision from correct, Your Honor. Yeah.
Okay. All right. So that's what I'm trying to figure out. I care about how the law develops in the case before me. I care as well about what it means going forward, which is why I'm asking about limiting principles or exceptions or areas where even you agree your argument goes too far. So you've conceded that finding in your favor potentially opens up the gates to private actions. It's not merely the commissioner who can bring actions. There can be private actions by the holders of the individual tokens if certain circumstances were to happen, or at least if they were to be alleged. Yes, sir?
Correct.
Okay. Now, one of the amici, the Blockchain Association, faults you for arguing
That was an oopsies by them.
that purchased with an expectation that its value will go up based on the entrepreneurial or managerial efforts of others is an investment contract. Is that what you're arguing?
No, Your Honor.
Okay, right. So, because a few moments ago you were saying to me you believed that Coinbase had itself pivoted and had changed from contract to something contract adjacent or contract. Here, that's how your test is being presented to me by someone in the space. What is it that you're actually arguing for? You're saying that there doesn't need to be a contract, but there's got to be something. So what is this something that there must be?
And that's a fair question, Your Honor. I didn't know if the court wanted us to address that position. The problem with that characterization from the amicus party is that that's lacking a common enterprise. Just if you buy an item and you just hope that it goes up, that's a lot different than buying into a common enterprise. And that, I think, is what this case is about. In terms of what we would look at here, what qualifies, if you look at the way that Judge Castell and Judge Rakoff framed this issue in terms of what is happening in a say a retail setting, which would be what this is, if there is an instrument present, and you're going to see in some instances that there are, because here we had the initial set, and that's why I mentioned earlier about kind of the history of each of these assets. They all tend to follow the same model, where you have those original direct placements, you have those original sets of agreements, as you did in Telegram and as you did in Terraform. And then what happens is when the blockchain launches and the network develops and then it expands, you then have people in the retail sense buying into, and that's why I said before, buying into this enterprise. And so the way Judge Rakoff and Judge Castell looked at it is they said that if you take the instrument and you take the full set of expectations and understandings that go with it, that is what constitutes the scheme or the transaction here. And Judge Castell was keen to note that scheme is not anything nefarious or pejorative. It's descriptive because it looks at the totality of the inducements. Now, are we saying that a contract can never exist? No, we're not. In fact, there are a number of digital token transactions that take place, not just in this case as it did initially, but just as it did. What we're saying is that a contract is not dispositive, that you can have the full set of expectations and understandings that embody the inducements. Now, in terms of that, I did want to point out, though, on Coinbase's changing standard here, with the impression of a contractual undertaking, because I think that Judge Castell got to this in Telegram, because Judge Castell had said that when the defendants launched this blockchain and then continued to publicly disseminate their plans to continue expanding and supporting it, they had an implied obligation to continue to do that. I think that's what Coinbase might be getting at here. They might be invoking Judge Castell's standard. And if that's what they're doing, then our complaint satisfies that standard, Your Honor, because you have in these instances an impression of that undertaking. I mean, if you look at an impression, it's something that I will think of when I see, hear, or read something. And you look at purchasers on Coinbase's platform. when they see, hear, and read all about these issuers, and they can do that easily because, as we mentioned as we alleged in the complaint, Coinbase links to that information directly, or the purchaser can read about it on their own. But when they look at all of this information, what do they see, read, and hear at the end of the day? They see, read, and hear that this is an investment opportunity, an opportunity to acquire a token as an investment into this network. And so if you add that up, the totality of the inducements in that sense, that is what makes this an investment contract transaction.
Once again, I presume you're going to say, based on our earlier discussions, that in isolating or selecting the 12 or 13 tokens that you have, you specifically looked at tokens for which there is this backstory, this suggestion of both origination and then development, such that any purchaser of such an asset either looked at or had the ability to look at this narrative of growth, development, and hopefully an increase in the value of the token. Is that your argument to me on that point?
Yes.
In Coinbase's briefing, they make the point that the assets that they list, and you'll excuse me, I'm not sure this may be in the answer, it may not be in their briefing, but they talk about the approval process that they have, the digital asset support group, and how that winnows away certain assets that are then not included on the platform. But what they say is that the assets that are listed, and I imagine by extension, therefore the 12 or 13 you've identified, involve no continuing promises from the issuer or developer to the token holder, impose no post-sale obligations on the issuer or developer, and involve no profit sharing between the issuer or developer and the holders. First of all, as a factual statement, do you dispute what they've said? I'm not sure that's, I guess my question is, do you agree and say it doesn't matter because of what you and I were just talking about, or do you disagree and say it's a factual issue that I won't be able to consider until the summary judgment motion?
No, Your Honor, we're not saying that. We agree that, sure, our complaint doesn't allege that there are contracts between the purchasers on this platform and the developers or the project team, sure. And we contend that the purchasers in these tokens are not getting a share of the ecosystem in the form of a distribution or dividend, sure. But the point is, those aren't requirements under Howey. Those are just added ingredients that Coinbase has decided to amend the Howey test with. So the reason we don't plead that is because that's not part of the test. And as we talked about with the contract side of it, this question about contractual obligations and how you want to characterize it and everything else, that's a question of state law. That has nothing to do with whether a security is formed. And on this other thing about acquiring a share of the business, getting a dividend or a distribution of some kind, I mean, Justice O'Connor, I thought, disposed of this in Edwards a couple of years ago, where she had said that when Howey uses the term profits, it's not limited to the profits of the scheme in which someone invests. It can also include an appreciation or a gain. In other words, it's the return that someone expects in order to participate in something like this. When you have an investment contract, somebody is giving over their money. They're parting with their capital, their cash, to participate in this venture, and they expect a return on that. They expect at the end of the day that they're going to get more money back. And they can do that either by a distribution or a dividend, or as Justice O'Connor was getting at, a gain. It's similar to stock in that sense, Your Honor, in the sense that a stock can generate a return in the form of dividends, right? Assuming that the corporation decides to pay dividends. The board might vote not to, but most of the time they do. Or a more popular way to get a return on stock is to sell it at a gain. And that's exactly what's happening with these tokens. People buy these tokens hoping, as we saw before with what the Chile issuer is talking about, demand is going to explode. So people want to buy these because they look at what the issuers and the project teams are planning, and they think this is a value proposition. So they can buy this token, this computer code, and then they can wait until the value of the ecosystem increases based on this. They're relying on these inducements.
And then when it does, then they can sell it on Coinbase's platform to someone else and realize a gain on it. That's what Howey requires.
But again, looking at either the limits of or the logical extension of your arguments, I am presented with the specter of collectibles being regulated by the securities industry. And I'm not minimizing. I mean, I appreciate some people, I've not thought about Beanie Babies in decades, and yet it's being presented to me in multiple briefs, and that's fine. But lest I be confronted with a class action about Beanie Babies, what you were, I think, suggesting to me a moment ago what the limits are. So I want to understand how your standard that you've just articulated to me does not sweep in collectible markets or commodities, which is my bigger issue. So what are, I think you were suggesting that it was the sort of the collective undertaking, but let me understand that, because it is a real fear that I have that your argument is just sweeping too broadly.
Ooh.
Sure, Your Honor. And first of all, we are not contending that collectibles are secure. So I'll just get that out of the way.
No one is, okay, to be clear, no one is actually suggesting that you are. We're all just afraid that you have so little limitation on your standard that some really thoughtful attorney is going to bring the Beanie Baby class action. So that's what I'm saying. Recognizing that even now you could forswear it right here. That doesn't matter. I care about how I know that your test isn't going to implicate either collectibles or commodities.
So the easiest way to look at this is that when you were buying a collectible, let's say a baseball card or a figurine of some kind, you're just buying the item. You are buying a thing. You are not buying into something, and that I think is the difference. There is no enterprise that is involved in this. If you buy a baseball card, for example, you're not buying into the baseball card player enterprise, right? Because there's and other people are not also buying into an enterprise, because that's what the common enterprise requires. You're just buying an item and you're hoping that it appreciates. That is not a securities transaction. There is a difference. And also, when you're talking about collectibles in particular, collectibles have their own value. There is no way for somebody to make a baseball card more valuable. It can't be done. It's the value of that baseball card is going to depend on customer tastes and passage of time and what have you. But there's no way to make that more valuable.
I would have thought, for example, in certain collectibles, I would have thought that akin to the burning that one has in crypto assets, you could have a limited edition figurine that would, or you could do something to limit the distribution of something, and that would increase its value. So.
Sure, Your Honor, there is that possibility, but again, I come back to this concept of this buying into something. You're not buying into an enterprise. In order for something to pass the Howey test, in order for it to be a security transaction, you have to have all three elements. It's not just one in three. So it's not just buying something and expecting it to go up. There has to be this notion of the enterprise. Now, what is the enterprise here? What is distinguishing these 13 tokens from a collectible? The fact is the enterprise. And what is the enterprise? It's the network. It's the ecosystem.
She purposefully keeps dodging the enterprise thing. She's not liking the SEC.
The token is the key that gets you into this ecosystem. Without the token, you can't get in. The token would be worthless without the ecosystem. It depends on it. And so when you have this collectible, you're not buying into the collectible, you're not buying into the enterprise, because there's nothing around it. Not to mention that there's no commonality there, Your Honor, in the sense that under Howey, you have to have multiple people doing this together who are all going to rise and fall together.
I'm just wondering if there are collectibles for which there is a group of people who are working together to ensure that there is a value It's almost, you don't want to dilute the brand, as it were. But I suppose that's beyond our discussions today. Just one moment, please, sir. I think I've talked to you or your colleague about the securities law scholars, so I don't think I'll discuss that with you further. I understand your standard of the common enterprise to be one of parting with capital with the expectation of profit? Or is that just part of the analysis?
Well, that would be the first prong of Howey and the third prong. The second prong is the common enterprise.
Okay, and I have to have all of them together.
Correct.
When you're discussing the Walls WALS case and the Lauer case, you suggest that because of the marketing of assets to unsophisticated investors, a court might find on those facts that an investment contract could exist without requiring ongoing obligations. I guess I have a slightly broader question than that, which is, to what extent today are you asking me to make a determination about the sophistication or not of crypto asset purchasers? And does it enter the calculus at all for me? Let's step back a moment. To the extent you want to tell me SEC, charged with protecting investors, really important, I get that. But what I'm really saying is my analysis of whether these assets are securities or not impacted by the sophistication or not of the investors? And could I even make a determination if it were?
I don't know that sophistication really is the issue, Your Honor. The issue is, sure, I mean, that's what our mission is to protect investors through disclosure. But in terms of whether or not a securities transaction is present, it doesn't matter the level of sophistication of these people who are buying these tokens, because the Howey test is going to be the same no matter what. In other words, I think this what I mentioned before, where we part issue respectfully with Judge Torres' view in Ripple, there's no need to create two different categories of people at the end of the day, because whether you're sophisticated or not, you're still buying the same token.
Returning to the issue of the reasonable expectation of profits, this is going to be a little bit repetitive, but it's really more to confirm for myself the questions I had earlier have been asked. When you're speaking about the reasonable expectation of profits from a third party's efforts, the third party here are the issuers and developers of the crypto asset and not Coinbase?
Correct, Your Honor.
Okay.
Yes.
Okay. I'm now going back. When we had our first conference, someone at the front table emphasized in a happy way the fact that this was just a consequence of the strict liability of the 33 Act in certain respects, which may be correct, but also may be a little troubling for me. And I was trying to figure out what it was that brought Coinbase into your crosshairs. And I suppose the real issue is that what it did was it placed on its platform tokens where the issuers of the token were developing an ecosystem and had big plans for enhancing the value of the token. So you're not suggesting that Coinbase acted with any bad intent or did themselves anything to enhance the values of the tokens, unless you are. I thought your point is by making them available for trading on the spot exchange through Prime. One would argue, somebody at your table would argue through Wallet, that's all they had to do. That it's nice that they sought investors. It's nice that they touted or at least provided information about these securities. But simply having them on their platform is enough from your perspective. Yes?
Yes, it is.
Okay, because see, the thing about Terraform and the thing about Ripple. I mean, Terraform. Judge Rakoff is, of course, brilliant, but the decision in Terraform was not a shock to me when you look at when you look at the way he describes what was going on in that case. The difference here is we're not talking about the issuer of the crypto asset. We're talking about an entity that put it on their platform. That, to me, is a level removed from Terraform. It's a level removed from Judge Castell's case. It's a level removed from Judge Barbadoro's case. And that's the concern I have about how these entities should have known. And you or your colleague saying strict liability doesn't make me feel better about it. How folks should know that they were implicating the securities laws. So I'm just confirming, at a minimum, the conduct was placing on the platform stuff that you now tell me amounts to a security.
Yes, the short answer is yes, Your Honor. We're not alleging any kind of fraudulent, no fraud or anything like that. This is just a strict liability in that sense. But I do want to back up because there's another part to Your Honor's question that concerns about, well, all of a sudden here's the SEC and applying Howey and now contends there are securities transactions. That's not quite the whole story. The SEC has been clear for a very long time that Howey is what determines whether something is trading as an investment contract. And we have been clear about that it doesn't matter in what context it trades, whether it trades in an issuer transaction or secondarily. If you go back to 2017, when we first released the Dow report, we were very clear in that report. We were cautioning secondary trading platforms that if they are intermediating securities transactions, then they have to register. That carries through into 2019, where the SEC staff released additional guidance. This is the information that we allege in our complaint and that Coinbase admits being familiar with in its answer. So we've been clear about that, and not only that, Your Honor, but Coinbase itself, at least according to our complaint, at least purported to do a Howey type analysis on its own when it came to the listing process for these crypto tokens, and they had a rather, what at least purported to be, somewhat comprehensive application. So when an issuer wants to list on there, the application requires the issuer to provide information about its founders, its project team, its allocation of tokens to the founders and the project team, its plans, its promotions, its accounts, its plans to encourage scarcity, to burn the tokens. In other words, their listing application that they, I guess, reviewed after they were done looking at it is exactly the type of information that appears in our complaint. And we have looked at the very same information that they claim, I guess, to have looked at. We reached one conclusion, and they appear to have reached another conclusion, which I suppose is a long way of saying that given that you can have two parties applying the very same standards, looking at the very same facts, and coming to the same very different conclusions, I think is all the more reason why this motion should be denied, just for that reason alone. But for there to be an argument that neither Coinbase nor the market was on notice of any of this, that's just not true.
I do want to turn to the major questions doctrine in a moment, and then we'll have a break, and then we'll have probably just as much questioning for the folks at the back table. They can rest up for it, but I would just like you to comment on one thing, and I know you have in different ways, but again, it's just to give me the clarity that I need for this decision. In one of the Amicus briefs, the one that O'Melveny did, I think that's Andreessen Horowitz, there's an argument that your standard converts the requirement of reasonable profit expectations from the efforts of others into a free-floating expectation of profits, even if the expectation is not enforceable, reasonably believed to be enforceable, or not reasonably believed to be enforceable, or not tied to the actions of the developer or promoter itself. Do you agree with each of those?
No, Your Honor. I think what that party is doing is just restating Coinbase's argument, but just in a different way. I think, as we talked about before,
The impression argument?
it's the impression argument, but it's the larger point on contracts. I think what you see in some of these briefs is that this requirement of a contract is not what makes something, is not how an investment contract is formed under the law. Howey is how it's formed. And whether or not it's enforceable is not a security kind. And on this question of, turning this free-floating thing into issuers and everything else, well, that's where the inducements come from in this case. They come from the issuers of these tokens. They come from these project teams. And as we saw looking at one of the examples earlier, I think it's pretty clear what impression these issuers are trying to give. And if you look at how the allocation of tokens played out initially, these issuers and project teams allocated the tokens to themselves. I mean, it really doesn't take a leap to figure out why that could be. And so when you look at the impression, to use Coinbase's term, that these issuers are giving, the impression is this is a value proposition. This is an investment opportunity. So we take issue, I think, with some of the characterizations in the brief.
Thank you very much for your patience, sir. When I became a judge, before I became a judge, I was quizzed by Senator Schumer. And one of the things he was getting at, although I'm not sure I'm supposed to disclose this here, is that he wanted to be sure that I was not going to be an activist judge. However, he defined that. And I'm not going to name the names of the judges in this and other districts that he was identifying as activist judges. I'll leave that for you all to ruminate about. But the point, the larger point for me, is that I recognize that I have a lane that I should be staying in. And there's a lane that you all are in. And there's a lane that Congress is in. And I actually have received a brief from a sitting United States Senator involved in this space who says to me, don't do this, Thela. I have to give that some deference, don't I? I mean, why is she wrong?
Well, thank you, Your Honor. I think that the reason that we have to be careful there, because I think that the Howey test was specifically enacted with the congressional intent in mind. That's what the Supreme Court said when they said, well, contract didn't define investment contract. What were they thinking, right? And so I think she's wrong, respectfully, to Senator Loomis, because one senator's view cannot override that Congress's will from 1934. I think that could get us very quickly into. So when I became a law student, I read Justice Scalia's book, and he didn't like legislative history because he said it's become a game, and a senator puts in something in the legislative history that says, oh, this is what this means, because he knows that then, respectfully, Judge Thela is going to look at it.
Yeah,
and,
well, he wasn't wrong.
That's right. So I think that I don't think that the major questions doctrine is built with the major questions doctrine is there to make sure everyone stays in their lane, and by permitting one senator to say something out loud and say, well, I just disagree with the SEC, I think that would create really more than just separation of powers concerns, but really structural concerns.
Okay, but she's not just random senator. She's someone who is deeply involved in the space and is herself a co-sponsor of legislation to implement the regulations or to implement a structure that she says is not found in the Howey test and that doesn't cover this specific group or type of assets. Why is she wrong?
And respectfully, Your Honor, I certainly don't.
By the way, you guys
think
can stop saying respectfully, because I always wonder what that means. I always interpret that as some insult, some silencio or insult, so don't worry.
They are getting smoked.
I'll accept that you're all being respectful of whomever you're maligning in your answer, so let's just go from there.
The press might not, Your Honor. So
Okay.
I don't. So to take a step back, certainly one of the factors that the Supreme Court has looked at in major questions doctrine is what congressional action or what Congress has considered. I don't see in these cases the court. Well, there's one case in which Chief Justice Roberts closed Speaker Pelosi. So it's not. I am certainly not saying that the court completely ignores what Senator Loomis or others are saying. I'm simply saying that it cannot be that a senator or even a group of them have the authority to sort of overrule or repeal what a Congress duly enacted presented to the president for signature in 1934. That could create all sorts of issues with all sorts of laws where.
Sure, but they're not saying they're overruling or repealing it. They're saying that we've had a great run. We've had 90 years for which these securities laws have been able to cover all manner of instruments, and now we've got something different. And these are instruments that, I'm not saying they were designed to evade the securities laws, but they're just differently, qualitatively, than other instruments. And so the argument is, we're not sure whether they're securities, we're not sure whether they're commodities, we're not sure who should have custody of them. But I'm not sure, I don't know that this is necessarily a repeal as much as it is a filling of the void as to a particular category of instruments.
Well, we simply don't agree that it's filling the void.
Oh.
And it sort of does, I think, expose a little bit of the circularity of Coinbase invoking the major questions doctrine here in any event. If it's not a filling of the void because the Howey test gives you the answer in either direction, and we think it's in the direction Mr. Costello explained, then you're not filling the void. You're simply applying the Howey test, which again was constructed specifically with the congressional intent in mind. That's what's so interesting about trying to apply major questions to the Howey test. The court said Congress wanted it to be flexible, and there's a line in, I think, Joyner, where the court said Congress specifically crafted these statutes to capture the countless ways in which people might think to raise funds for their projects. I'm now giving a more abbreviated version of the Howey test than Mr. Costello did, but the point is that's what Congress has wanted to do. And so applying the Howey test to new types of investment schemes, investment products, is in fact nothing new, to be a little circular. The courts have been applying there's the case where there were cattle embryos. Payphones, I don't know if payphones existed in 1933, but let's assume they did. There are Court of Appeals cases about, what were called attacks on the internet in the 10th Circuit, and there's the SG Limited case in the First Circuit. So courts have been applying the Howey test, the flexible Howey test, to these investment schemes for decades. And that has, by the way, not resulted in people bringing the Beanie Babies lawsuit, but more importantly, courts have been doing that because they thought that in doing so, they were affecting the congressional purpose. And so, that's it.
That was abrupt.
Oh, they're getting smoked. Absolutely smoked. She's not resonating with a lot of their arguments.
Dispute, I would say, between Coinbase and some of the amici about the significance of the crypto asset industry when compared with something like the energy industry or student loan debt forgiveness. I don't know that the Commission really spoke to that, and if you want to speak to that, please do so now.
Yes, Your Honor. So there's it's important to contextualize the size. The Supreme Court in the cases, so there's a number of major questions cases, right? Some of them have used...
I didn't think there were that many, but go ahead. All right.
Somewhere between 5 and 8, depending on how you count them.
5 and 8, yes, okay. Hardly a number, but go ahead. Yes, go ahead.
So the court, in the cases where the court looks at the size or the economic significance, there's a number of ways in which the court does it. One is the cost of compliance, and I think that's the landlord's case, the Alabama Realtors case. They look at the cost of compliance. In other cases, they look at sort of the expansion of the agency's scope. The utility-air case, they say...
Slow down. Thank you.
In the utility-air case, they say, in one category you had 800 permits, and now you're going to have 82,000, and you're going to increase the cost of compliance from $62 million to $21 billion. In other cases, the Supreme Court looks at sort of the totality of the American economy, and they'll say, in the evictions case, they'll say 80% of the country might be affected. And in the student loan case, they say 98% of borrowers might be affected. And we're talking about $500 billion in debt, in student loan debt, versus $1.7 trillion in spending. So I'm giving that as context to my answer, which is no matter which of these sort of, excuse me, versions of the economic significance factor one applies, with all due respect to the crypto industry, it does not meet that version. So there's a number of ways to look at it. So first of all, they're playing a little fast and loose with the number, because they say, well, it's 1 trillion, but that's really a global number, and I haven't seen that in these 5 or 8 cases, right? We're looking at the American economy. They're saying that Bitcoin, 1.1 trillion includes Bitcoin, which is not an issue here, and is a significant portion of these markets. So already there, they're giving the wrong number in our estimation. And then they're not comparing it to the right number. The commission regulates the 100 plus trillion capital markets in the United States. The size of the global capital markets is north of $400 trillion. And so when one looks at that, again, I'm going to say it with due respect to the crypto industry, they're a rounding error in that sense, right? 1 trillion is a rounding error when it comes to the global size of the global capital markets. And so for this quote-unquote new asset class to be somehow swept in, and of course that's not what we're doing here, right? But even accepting that premise would not constitute a significant expansion of the Commission's jurisdiction over the capital markets. So that's the context in which I think we need to look at that 1 trillion number that they offer.
Okay, thank you very much. Just one moment, please. I'll see if I have additional questions for you.
Hey, while she's on pause there, a quick reminder, I put a full summary at ehack.com.
Wound up in the major questions doctrine, or sort of adjacent to the major questions doctrine, is this idea of the SEC violating Coinbase's due process rights. Are you the person to speak to that issue, other than to just say, no, we're not? I mean, or is there someone else at your table who wants to just briefly address that issue?
Your Honor, I think Mr. Costello addressed it in some ways, but I'll try to repeat. We are not, and the reason we are not, so if it's a fair notice argument, that's a due process argument, I think, and we are not violating Coinbase's due process rights or violating fair notice principles. The courts have been clear that if we apply Howey, that's the notice you need. Judge Deary and Brooklyn said it in 2018. If anything else were needed, we issued the Dow report to sort of make clear the Commission's position. And what fair notice and due process require is that the party know, the regulated party, particularly in the context of civil regulation, that the party know the test that's going to be applied, not the outcome.
Okay, thank you very much. Let me do this, because I tend not to look at time until my deputy tells me I should look at the time. We've been 2 hours at this, and it's been very productive. I imagine we're going to have the same discussions with the back table. It'll be somewhere in the 90 to 120 minutes mark. I'm going to take a break of 15 minutes just because folks have been sitting here for 2 hours or more, and I want you to have that. If folks had plans to break for lunch, someone, and I mean really the folks at the front 2 tables, I'm sorry, don't care about the rest of you in the gallery, but if folks have plans, I didn't think you did, tell me, and I'll see what I can do. But my plan was to go and to finish questions for the folks at the back table, and then allow each side very brief.
Back table is Coinbase.
Sense of anything they wanted to tell me, but I didn't ask a question about. That's my plan. If you guys have different thoughts, talk to each other and then talk to me in about 15 minutes. I'll see you then. Thanks very much.
Okay, so we have a 15-minute break. We will. Coinbase is next up. So the summary is over at ehack.com. I will provide a summary as well. Coinbase is next up. Summary at ehack.com. SEC kind of got hosed. That's loud. So we're just going to stand by and hang out. Good time, yeah, to get some coffee, get some food, whatever. But I'll give a summary here in just a moment. Actually, I'll just give you a summary now. So let's do a summary here just so you can kind of get a feeling of what's going on so far. In case you're just now tuning in, I want to catch you up because honestly, the SEC, I mean, like, Coinbase doesn't need to say much, in my opinion. I mean, the judge is going to ask questions, but Coinbase does not need to say a lot. The SEC, they didn't do really well. Now, the biggest thing that the SEC argues is that tokens are a common enterprise. That basically, according to the Howey test, which has 4 characteristics for what a security is. Number 1, the investment of money. Yes, we have that. Number 2, in a common enterprise. I don't know, do we have that? With the expectation of profit. I don't know, do we have that? To be derived from the efforts of others. Ooh, that's another good one, right? So let's say you have an investment of money with the expectation of profit. That's fine, but that doesn't necessarily make crypto like a token or whatever with developers and DeFi or whatever a security. Security, because the judge is parsing out here and saying like, hey, well, is there an investment contract up front? Was there the opportunity for an original investor to rescind the contract? Oh, there wasn't a contract. Oh, okay. So how is this different from a Beanie Baby? Because if I say that, some token like Solana is a security, then what happens if next week I get a lawsuit saying Beanie Babies are a security now? Like, what makes the two different? And the SEC is arguing, well, it's different because the Beanie Babies value doesn't go up because of the efforts of some other company to provide a better good or service. The SEC is basically trying to say, like, if you're going to invest in the metaverse, the metaverse's value might go up based on the efforts of a developer programming better, integrations for the metaverse, right? And so if a developer creates better integrations for the metaverse or better experiences or whatever, then the value of the metaverse could go up. And if there's a token that represents the value of that metaverse, then the token is basically a security. She kind of ended this by saying, look, I've basically straight up, she's like, I've been told by other senators just not to get involved in this, to stay out of it and to stay in my lane. And you all are telling me, no, I should call this a security. And she's like, but maybe this is a thing on its own. Maybe it's not a security. Maybe it's a class of its own, right? So far, all of that sounds really, really bad for the SEC. The SEC has a lot of cleanup to do right there. Now, this whole case right now, this hearing is basically asking the judge to either let the case keep going or to decide on the case now on sort of a summary of the pleadings, so to speak. It's sort of a way of saying like, hey, based on what you've heard so far, can you make a decision? And so obviously the judge is hearing both sides. We just heard like 2 hours of the judge basically explaining or asking questions of the SEC. The next part is going to be the judge asking questions of Coinbase, and then you're going to get a summary from both sides. So, I have to say, so far, it doesn't look good for the SEC. Now, I personally, I'm trying to understand the argument of the SEC, and I get it. Like, it's if you invest in a certain token, the argument is, hey, you're investing into the efforts of the developers working in a token. But where it gets a little blurry is that a security doesn't necessarily have to, not apply to the Howey test to not be covered by the SEC. Okay, that was really wordy. Let me phrase it this way. Let's say you own Coinbase stock and you meet me in my garage and you have, paper that represents Coinbase stock, okay? Let's say this right here is an envelope of Coinbase stock. And you hand it to me and I hand you cash. Did we just conduct something that the SEC has the right to regulate? And the answer is no. Even though technically Coinbase stock is a security, we're able to trade stuff amongst each other privately in what's known as an exempt transaction. And the SEC does not have jurisdiction over an exempt transaction. Instead, the SEC gets to regulate new issues. Okay, so new issues are basically, this has to do with like the 1933 like Securities Acts and Exchange Acts of 34 and stuff like this. All these laws, they go back like 90 years. But anyway, the SEC's jurisdiction basically comes from this idea of, look, we want to make sure that when issuers issue a security, they provide proper disclosure. So for example, when my real estate startup raises money to Reg A investors, which means everyday investors who are not accredited, I have to register essentially, or I have to file disclosures with the SEC, and then the SEC can look and qualify what we wrote. Now, they don't approve it because they don't say like, oh yeah, we agree with your disclosures. They just go, did you include all your disclosures? That is a way of the SEC having authority and making sure that the proper disclosures are provided by an issuer to the investing public, right? So what the judge here argues is, hey, whoa, wait a minute. The SEC is not complaining about the individual tokens in this case. They're actually complaining about the tokens listed on an exchange and therefore suing the exchange for that. And it's really interesting because that's a big, like, kiss of death right there for the SEC, because the judge is kind of like, hey, like, why don't we first figure out if there's securities rather than suing Coinbase? Like, really big siding there on Coinbase, right? Because it kind of feels a little like backwards. Like, why are you getting them in trouble? They didn't even know it was a security because you guys haven't even figured that out yet or proved that anywhere else that these are securities. So that was a big hit to the SEC. And another big hit to the SEC, which actually I should put this on the EHAC. Most of the summary I've just given I've put on EHAC, but I think something else that was really, really interesting was it had to do with the exchanges. So basically you have the SEC arguing that, hey, we don't have, I'm going to write this down. So I'm going to put this on EHAC as well really quickly. So I'll put that at the top of EHAC. I actually think that was a pretty big argument as well, what I'm about to tell you. So SEC argues that Coinbase is an unregistered exchange because they bring together buyers and sellers. And then they argue that there's a conflict between broker-dealers also being an exchange and also being a clearing agency, which settles transactions, okay? That's what the SEC argues. And what was wild was the judge comes back and says, hey, you know, is that illegal? Like, basically, is that against the law to basically have an exchange that's also a broker-dealer? And the SEC comes back and says, well, that's not illegal per se. We just have never approved an exchange that was also a broker-dealer. Okay, so why is that a big deal? So I just updated that onto the top of ehack.com. There we go. Okay, so why is that a big deal? Well, it's a big deal because the SEC is basically like, well, like, you know, we don't like that an exchange is also a broker-dealer. And the judge is like, why don't you like that? Well, there's a conflict of interest. Okay, well, is that illegal? Well, no, it's not illegal, but there's a conflict of interest. And the judge is like, okay. So it's actually really, really interesting because, you know, the SEC got cornered on multiple things here. So if I had to put a summary together, so far, so let's do that. Summary of problems, summary of issues for SEC so far, okay? So we'll put that together. And while we wait for their break to be over, I still have, just want to make sure. We're still good? Yep. Yep, we're still on the call. Everything's still good. Okay, so summary of the issues so far. Let's write this down. So first issue we have is the fact that the judge basically argues that crypto might be sort of a breed of its own, right? What makes crypto not its own thing, right? Versus a security. That's a big deal, okay? Then, what makes crypto not a collectible or commodity? Okay, I just heard somebody on the phone, but it's some rustling. Okay, so that's another thing. Another thing is it illegal to have an exchange also be a broker-dealer / clearing agent? And the SEC says no, just a conflict of interest. Okay, then we have, so it could be its own thing. It's not a collectible or commodity, so we need to differentiate between that. Is it illegal to have an exchange that's also a broker-dealer? The answer is no. It's just a conflict of interest, and we've never approved one. Then we have the argument that there is no primary issuer transaction. Okay, this that is very clearly associated with the security. That's a big question. That's a big statement there. So primary issuer transaction. Let's understand that really quickly. So a secondary transaction is, again, when you and I exchange shares of Coinbase. So again, let's say this is Coinbase stock right here in my hand, okay? I hand this to you and you give me donuts or dollars or whatever for it, okay? That is an exempt transaction. So the SEC does not have authority over those sort of secondary transactions, right? So let's write that down. Secondary transaction, SEC does not have authority due to them being, quote, exempt transactions. So then the issue is, what about primary issuer transactions? Well, the judge asked, is there a contract with the buyer? No. Is there a right of rescission in crypto? No. Now, why is that really important, this right of rescission? Well, because a right of rescission is another way of saying there's a contract. And so the judge kind of backed them into that. So primary issuer transaction, is there a contract with the buyer? No. Is there a right of rescission in crypto? No. But there is a right of rescission in a primary securities contract, right? Yes. So those are some really, really, really big issues there that the SEC is going to have to overcome. I just summarized those at the bottom of EHAC. Again, we're just waiting now a few minutes. I think we're about 5 minutes away maybe from getting back to additional, let's see. Okay, there we go. Oh, wait, hold on a sec. Hold on. Let's just see. Okay, there we go. So, okay, let me think about this straight again, because this is a lot to sort of ingest. The SEC is getting hosed. The SEC is also, and I thought this was very interesting, not saying that the DeFi Amicus brief is wrong. Now, the DeFi Amicus brief, okay, so let's understand that. There's a lot going on here, I promise. I'm going to try my best. The DeFi Amicus brief has a very, very simple explanation for what wallets are and what staking is. And, oh, that was another big argument on staking. Let me come back to the wallet thing. So on staking, the judge is like, hey, you're saying staking is now all of a sudden the benefit of somebody else's work. But wait a minute, isn't me putting my money in a savings account kind of like staking? So judge asking, isn't me putting my money in a savings account kind of like staking? That's a big blow to SEC right there, that comparison. Again, then regarding wallets. So judge asks if there's anything wrong with the DeFi
I'm talking to you, sir. Can I begin, please, with some of the preliminary questions that I had for the commission? I believe you have a different view, sir, as to the degree to which I can take judicial notice of your factual statements and of the factual statements in the amicus briefs, but may I hear from you on that, please?
Yes, Your Honor. Thank you. We agree with the commission that the materials for the court and the posture of this motion are substantially similar to what they would be in the context of the 12b6 motion. Of course, the well-pleaded allegations of the complaint are before the court, as are all matters properly before the court as a matter of judicial notice, and all documents incorporated by reference in the complaint. To the extent there are public statements of the SEC, the officers of the SEC, those we believe are properly before the court as a matter of judicial notice. To the extent the litigation involves legislative proposals that are a matter of public record, they too, we believe, are before the court as a matter of judicial notice. We think public filings are before the court as a matter of judicial notice. We think the S1 filing of Coinbase is before the court.
Two things, sir. Please excuse me. First of all, for reasons known best to my courtroom, your microphone is not as strong as some of the others. Can I ask you to bring it a little bit closer to you, because I want to be sure we can hear you. I think it's not, trust me, it's not you, it's the microphone. Second, just so I can take better notes, if I could just ask you to just speak a little bit slower. I thank you so much. Go ahead.
Of course. No, thank you, Your Honor. Apologies. So we think public filings, SEC filings, are a matter of public record and properly before the court, accordingly as a matter of judicial notice. That includes Coinbase's S1 filing. There have been the court has seen the discussion of Chair Gensler's remarks. We think they are properly before the court. There are a number of documents incorporated by reference into the complaint, including Coinbase's user agreement. Those are properly before the court. To the extent the complaint makes reference to what appears on Coinbase's website in connection with its allegations, those are properly before the court. So we agree that this is a pleadings motion, and it's governed by all of the rules that govern what's before the court in the pleadings motion, but there is a quantum of matters that the court, we think, can properly take cognizance of as a matter of judicial notice or through the incorporation principle.
And so from your perspective, sir, everything in those first 33 pages fits into one of the categories you've just articulated for me, and I can therefore consider all of the factual statements contained in your, the first 33 pages, I believe it's 33 pages of your answer.
I do not think I agree with that, Your Honor.
Oh, okay.
But what I can't do is catalog for you what's in and what's out off the top of my head.
Okay, but even you're saying there may be a few things. You're admitting of the possibility that there are some things in your answer that are interesting, but I can't consider.
We agree with that. Properly before the court are the plaintiff's pleadings, the well-pleaded allegations of the complaint, matters of judicial notice, matters that are incorporated by reference. You had a colloquy with my friends at the front table about whether certain matters that were in briefs by law scholars and the like were properly before the court. That's an interesting question. I think the answer would be to that yes, because they do not seem to us to be matters of factual dispute. Even in the motion to dismiss, a court is permitted and I think expected to take account of what's happening in the world and the contents of scholarship and facts that are not truly matters that are disputed in the litigation, the background of an industry, for example. I think that's common, appropriate, and a matter of judicial notice. So we wouldn't exclude those matters, but we wouldn't say that every factual allegation in our answer is before the court.
Much appreciated. With respect, for example, to the scholars, we have two sets of scholars. There's the sort of the state law, blue sky law scholars, and then the admin law scholars. I suppose the answer is that I could look at those same cases myself and come to the same conclusion. So it's rather than think of it as giving me facts that I must accept or reject, they are pointing me in the way of cases that say or don't say what they're represented to say. But I appreciate your thoughts on that. Again, sir, some of these questions were specific to the commission because they are the ones bringing the complaint. But I would like to understand from your perspective whether the focus I should be focused solely on the secondary market here. There was some discussion with the SEC about Asset Hub and what it does or does not do, but I'm assuming that, particularly given the nature of the arguments you're making to me under the Howey test, that my focus is on the secondary market. Is that your understanding as well?
It is, Your Honor. We think we understand the allegations of the complaint insofar as the investment contract issue, the Howey test issue is concerned, to relate to the trading of 12 tokens on Coinbase's secondary market, either the prime platform or the spot market, which are all blind bid-ask transactions, and we believe that those are the only transactions that are properly before the court. There is, as the court noted, a passing reference in paragraph 65 of the complaint to Asset Hub. That's the only fact in this lengthy complaint that even references primary sales. that allegation references Coinbase's website. We think that is properly before the court, and if you click through to the website, you will see there that that is not a source through which issuers can sell tokens. It supplies no basis for the court to consider or for the plaintiff to put before the court the issue of primary trading. There isn't anything here that relates to primary trading at all. This case is about secondary trades on the spot market and the prime market between strangers.
Let me ask you this. I thought I understood Coinbase's submission to say to me that the assets, these tokens, are not securities in the first instance, and therefore, by extension, secondary transactions in things that aren't securities are not themselves transactions involving securities. Was that, in fact, the argument that Coinbase was making, or is Coinbase arguing that these assets may, in some circumstances, be securities, but that the particular transactions that one can have on the spot market, on prime, through wallet, through staking, that those are simply outside of the purview of the securities laws?
Your Honor, let me try to answer the question this way. We are skeptical that crypto tokens, that these digital assets can themselves be securities in any scenario. And while I listened with care to your conversation with the Commission earlier today, I believe that's where they ended up too, that the tokens themselves are not securities. And I think that is common ground, and I think that would be our position. That's a different matter, though, Your Honor, and I wouldn't want to be heard to overstate our position as to whether transactions in these tokens and be on the primary or secondary market in some set of circumstances investment contracts and therefore securities. We do contend with force that the tokens that trade on Coinbase's secondary market that are before the court in the complaint are not, as a matter of law, investment contracts and therefore not securities.
I really appreciate the clarification that you were just giving me, because I thought it would have been easier to say they're not securities, they can never be securities, and therefore any transaction involving them cannot be a security. I understand you now to be saying that there is a possibility, well, that the assets themselves are not in and of themselves securities, that there are perhaps theoretical possibilities where transactions involving those assets could be investment contracts, but that the particular transactions at issue in this case, as described by the Commission, do not implicate the securities laws. That's your argument?
That is our position, Your Honor.
I appreciate understanding that better than I did when this began, so thank you for that.
Okay. Good so far.
If the assets, these crypto assets, are not themselves securities, okay, they're tokens, why does one buy them? And according to the Commission, one of the reasons that one buys them is that they might appreciate in value. There are other reasons, to be sure, but one of the allegations in the complaint is that they're being bought with the theory that there is some value to them, or perhaps some value in transactions involving them, such that they would appreciate value. But why does one buy a token?
I'm not sure that I want to give the devil its due, but I want to give the Commission its due.
Okay.
We do not contend that there are inadequate allegations in this complaint to establish that some tokens are traded on the Coinbase platform in the hope that they'll appreciate. We're not saying that's true, but for a matter of the pleadings, we understand that to be part of what the front table is alleging, and no part of our defense on this motion goes to that point. I appreciate that was a slightly indirect answer to Your Honor's question.
Yes, I did notice that too.
But I say it because I did want to make that point clear. We want to join issue with the SEC on the actual controversy here, and that's not what it is. As to why people buy tokens, I should say, at the risk of being cross-eyes with my client, I don't know. I never bought one. I
I think there are multiple reasons people buy tokens. I think they can be purchased for investment. They can be purchased for utility. They can be purchased to swap and trade. I think there are any number of reasons. But insofar as matters here, we will accept for purposes of the pleadings that some trades may happen on Coinbase in these 12 tokens on the secondary market, in which one of the objectives is investment gain.
All right. So you just said a moment ago you actually want to join with the commission on actual arguments and not some of these more esoteric or theoretical matters. So what are the arguments in which you join? Your arguments are that the transactions alleged in the complaint are not themselves investment contracts. Not that there couldn't be, but that these aren't.
That is our argument, Your Honor. And as I said a moment ago, we don't take the view that token transactions on primary or even potentially on secondary markets can never be an investment contract. I think we could have a conversation in which we could imagine transactions that would look like investment contracts, but it requires allegations of fact that are missing in this complaint. And to be clear, we want to give the full perimeter to the Commission's position on its pleadings. We know that the court will give every inference that's reasonably drawn in their favor. So we want to give those inferences because we think even with that perimeter, we have arguments that should prevail, which is the point I was trying to make about not wanting to draw a caricature of the position on the other side, but to give it its full berth.
No, much appreciated. Thank you. So according to the commission then, as I look at these transactions in the secondary market through Coinbase, through services offered by Coinbase, I don't just look at the purchase of the asset. I look at what the purchaser is getting. And according to the commission, the purchaser either is aware of or could be aware that one of the reasons that the buying this token buys into the ecosystem, the goals of the issuer, whether they be to build a better blockchain or to develop apps for that blockchain, or otherwise promote whatever the blockchain is. And so what they're suggesting is that by dint of there being statements from promoters and developers and issuers, and by dint of those statements being included on Coinbase's platforms, that I can understand, at least for 12b6 purposes, that a reason that that customers are buying these tokens is in order to advance the goals of the issuers, to join that common enterprise. Could you tell me, please, why they're wrong?
Well, I should say I don't think all of that is wrong.
Okay.
And here again, this is in the spirit of trying to flesh out the position on the other side.
Yes, I'd like to know what you agree with and what you disagree with. Thank you.
We think so much is true for purposes of today only, for purposes of the pleadings only. It's alleged that there are purchases on the secondary platform in which buyers buy tokens with knowledge of the statements of intent of promoters with respect to the things they may hope to do on their blockchain or otherwise with the token that they've issued. And that those statements may well be in the understanding or consciousness of a buyer when he, she, or it purchases the tokens. Whether that constitutes buying into an ecosystem is something I don't know that we believe is adequately pleaded. I'm not quite sure what the phrase buying into means, and we're at a point where distinctions like that I think may matter. But we would acknowledge this. You have the purchase of an asset, and what it's accompanied by are statements of promotion, statements of intent by a promoter, which a buyer might believe, if they were followed through on, which they may or may not be, could create a rise in the value of the relevant investment. So to that extent, we do agree with the SEC. We depart, of course, Your Honor, on the question whether that is enough in any reasonable conception of an investment contract, whether looking at it as a matter of statutory construction, given the words of the statute itself and the sections of the statute in which it appears, or within the contemplation of the contract, that can constitute an investment contract. So I think the answer there is no, there isn't enough.
And what is it? Right. So I believe the commission is suggesting, and I'm going to very much minimize and dumb down their position, but they're suggesting, as you were just saying to me, that the purchase of an asset with knowledge of the statements of intent could lead one to believe that the person is purchasing the asset as some sort of espousal of or hope to continue whatever those statements of intent are. If your token is going to change the world in some great way, by buying your token, may say, I agree, I think you should change the world in that way, and I hope that you do, and I hope that all of that leads to an appreciation in the value. For you, sir, for your team, that is not enough. I'm saying what's missing, and you're going to say some contractual, some ability to enforce, and I want to understand what does that mean, and I am asking you to describe it at its most basic level so that I understand it.
Completely fair, Your Honor, and understood. There were, in a sense, before getting to that, with apologies, Your Honor said that the SEC's position involved buying a product to advance the interests or the ideas of the promoter, and I hear that.
Well, let me be more specific, because I don't think I was complete, because I think in so doing, they're doing a couple of things. They are, number one, joining the common enterprise of that issuer, of that developer, and number two, they are doing so with the hope that there will be some gain in the form of token appreciation as a result of that purchase. So it's not just, you're not, for some reason I'm thinking about those folks who pick the NCAA teams based on the color of the uniform or something like that, with no, and I'm not saying I was those people, but I'm not saying I was those people, but I'm just saying, so you could pick a token because you think it sounds really cool, or because your friend has that token and you want to be just like your friend. But I think what the commission is arguing is that there are purchasers through Coinbase who are looking at a token, looking at the developers, looking at what the issuer hopes to do, and aligning themselves with that, and thereby they say joining that enterprise. I thought that your position was that there's an absence of on the part of the purchaser some way of enforcing that or getting something from that, and that's the problem. But I'll let you speak.
She's feeding the argument to them.
Say that, and our friends at the front table picked on us a little bit this morning on this, but we deserve it. It's the right question to push on by the commission and the court. What we say, and we think this is truly faithful to the statute, truly faithful to the securities laws and their purpose, and truly faithful to the cases, is that what is required, at least at a minimum, is the holding out of an offer of an investment that includes a statement meant to convey to the offeree some sort of enforceable right. At a minimum, that much is required as a securities law matter. And so, just to play dumb here, what does that mean? I mean, I guess I'll ask. You heard me ask Mr. Costello whether the logical extension of his argument was that purchasers of these tokens suddenly got rights under the securities laws. I'm asking you the converse. You're suggesting, if I bought Sol or one of these tokens and it went belly up not because that's just the way the world is, but because of something bad that happened by company management, which of course I'm not saying is actually happening, am I just out of luck? Is there, or am I limited to common law, contract, and tort rights, but just not rights under the securities laws? Very much the latter, Your Honor. That is to say, the purchaser of Sol in the court's hypothetical would have claims sounding in fraud, were there a fraud, and there may or may not be. It's conceivable would have claims sounding in contracts, although it doesn't. But
you've just said to me there's no enforceable. I mean, we're talking about a situation where there is.
He's burying himself.
Statement of enforceable right, which would suggest there is. What's the contract then in this attenuated transaction between the purchaser and the ultimate issuer of the asset?
And it's a great question, and I should be clear. So fraud, of course, we don't have the contract problem. It's a tort, as I know the court knows. And the most natural place where there might be a cause of action in that scenario. If there was fraud, was fraud. And the court no doubt has seen when it's reviewed the investment contract cases, and some number of them either decline to find investment contracts but say there could be a fraud claim, or find fraud claims under common law in addition to an investment contract. One could imagine a scenario where there was some sort of contractual relationship between the buyer of a token and a promoter that was not sufficiently linked to the investment that it would constitute an investment contract. They could have contractual relationships otherwise than constitute an investment contract. But the real bottom line we want to push on is that there is a distinction between the securities laws and the law of contract and the law of tort.
He's overcomplicating.
Mr. Costello made reference to the Joyner case earlier, and it's an important one, I think, and it informs much of our thinking and perhaps much of the Commission's. In that case, there was some question whether there was a state law contract claim. And it's very interesting when one traces it through the lower court decisions and you see that what's happening is a debate amongst the circuit court about whether there's an implicit contract or an explicit one. And the Supreme Court, as the court saw, found it unnecessary to resolve that question, because what it found was that there was a sufficient holding out of a contractual relationship that satisfied the securities law test, so as to render the precise state law contract question unnecessary for disposition. Judge Boudin says something to the same effect in the Rodriguez case.
What? He's burying himself.
And that it's that sufficient holding out of a contract is what you find to be missing from the transactions at issue here.
In candor, Your Honor, that's a little bit of an understatement. We think the complaint is truly devoid
Better.
of anything that could
plausibly
better to a promise that's enforceable by an issuer to a secondary buyer on Coinbase's platform. And
way better.
And I'll raise, and I hope it's helpful to raise it at this point in our conversation, a couple of cases that really came to mind when you were chatting with Mr. Costello on largely this subject. The Rodriguez and Deleuze cases, those are cases in which real estate developers undertook to sell plots of land, made all sorts of promotional statements about what they were going to do. They were going to put electricity in, they were going to build roads, there was going to be a country club, there was going to be a meeting house, I don't know what, there was going to be all sorts of stuff. There was a thing called Rancho California in Southern California. This is the Duluth case. It was going to be great. It was going to be great. And then there was the Disney World developments near in Florida that were at issue in Rodriguez, and those were cases feel a lot like the argument that we're hearing here, Your Honor. There's a promoter. The promoter is making promises that it's going to develop a real estate ecosystem. Those promises were on their face not enforceable by the buyers. And when the sales were made, and in retrospect, the buyers were aggrieved by their purchase, they sued under the securities laws and said investment contract. And the court said no investment contract. And the reason was that promotional statements aren't enough. Even promises in the ether aren't enough. There has to be sufficient undertaking of an apparently legally enforceable character so as to give the buyer a claim. That's what those cases said in what we think are highly analogous circumstances. And I don't think there's any surprise in that. It is, to return to first principles, Your Honor, if the words are investment contract, it oughtn't come as a surprise that people look for a contract. And that has always been the touchstone.
Sure, but then we've got the whole scheme argument.
Well, we do have the scheme argument, Your Honor, and that's what we thought we were going to be confronted with when we came to visit with you in July.
And we weren't.
And we weren't. And we think there's a reason why, Your Honor. We demonstrated, we think, to a fairly well, that the only way to understand the word scheme as it appears in Howey, and has been echoed down now through the generations, is as part of a scheme of contracts, a series of transactions and contractual undertakings that, taken together, constitute a whole. We were so confident we were going to be confronted with that argument, we addressed it in our opening brief. And it was met with stunning silence. That argument went off stage, left, never to return. And we don't think that's in the case anymore. We certainly don't think it's a position that's been defended in the answering brief, and we think the reason is clear: it can't be. It's not what the blue sky cases taught the investment contract meant. It's not what Howey meant when it brought in the blue sky cases, and it's not what's ever been meant in the cases since then. Every one of which, Your Honor, since putting aside at any rate the recent crypto enforcement blitz, every one of them has involved a cognizable contractual undertaking, no exceptions. And Your Honor, that reminds me that I was remiss in failing to ask you whether, notwithstanding the character of the argument, we could hand up some slides that we made that bear on a couple of issues we might want to talk about.
I'm sure someone stayed up through the night putting them together, so yes, please.
Thank you, Your Honor.
I'm sure they're wonderfully done, and I appreciate the effort, so yes.
She is so nice
With the folks at the front
to
table.
Coinbase. She's giving everything to Coinbase here. She's handing this win to Coinbase so far. And now she's letting Coinbase present with slides. She agreed that nobody's talking right now, by the way, so we're not missing anything. But anyway, she agreed.
I was going to play the someone stayed up all night card if it was necessary. Your Honor. We have a great team of lawyers who have been working hard on this, so thank you for that recognition. And it came to mind because one of the slides in here, and the court will either look at it or not.
I have it in front of me. Is there something you want to direct my attention to right now, sir? And it's fine if this is just more for after you all leave and I have nothing to do.
Well, since you asked, Your Honor, let me. The page 2 here is one that it relates to an issue that we talked about, and the point we would like to make as a first principles point is that everybody has always known that investment contracts have to have contracts. So this is an excerpt from the SEC's brief in the Edwards case that Your Honor heard about this morning, and they talk very specifically about the meaning of these two words as they appear in the 33 and 34 Act, and quite unsurprisingly, they observed, the Commission did, before it decided that it wanted to expand its jurisdiction in respect of crypto, that the second word in the quoted term contract means an agreement between two or more persons to do or forbear something. It has never been the Commission's position before the crypto cases that a contractual undertaking was not required. And the additional point, Your Honor, that I would call your attention to is slide 6.
Just one moment, please. I'm still slide 2. Thank you.
This is big so far. Coinbase is doing pretty well. They could have done better. They could have done even better. She handed a few easy wins to them, and they dodged a couple easy ones.
I'm sorry, Your Honor. I just, knowing that time and life is short, we didn't want to belabor all of these cases, but these appear to us to be the universe of controlling cases in this court, the Second Circuit and Supreme Court cases, on investment contracts, and every one of them involved a contractual undertaking to deliver future value. Every one of them until the crypto cases. And of course, there hasn't been any circuit or Supreme Court authority on those matters.
Before we put this to the side, sir, there are other slides you want to call to my attention at this stage?
Not at this stage.
Okay, thank you.
Thank you.
I'll keep it nearby just in case. Thank you. Sir, I want to actually back up. I know we should be going forward, but I am moving backward. I had extensive discussion with the Commission about what conduct of Coinbase, what it is that your client actually did that brings them here today. And part of the reason I was asking that question was to figure out whether there were factual disputes that foreclosed a motion to dismiss based on the conduct alleged, or whether everybody agreed on the conduct and they disagreed as to the legal import of that conduct. Are there, I know from your submission, I know from the DeFi folks' submission, that there is some dispute about what actually is involved with the wallet program and with the staking program. But perhaps including that, are you accepting the Commission's allegations of Coinbase's conduct and saying that they are nonetheless insufficient based on the argument or the discussion we've just been having to implicate the securities laws? Or are you saying otherwise, that there is a dispute, but it's obvious from my read or my ability to read materials of which I can take judicial notice or that are fairly implicated by the pleadings, the complaint, that I can determine that your view of Coinbase's conduct is correct.
I think, Your Honor, for purposes of this motion only, we are accepting the allegations that the complaint is true. I do hasten to add that they need to be well pleaded, and by that I mean that they have to plead facts rather than conclusions.
Oh, of course, yes.
And that if they rely on a document, the court can and should resort to that document to verify the well pleaded character of the complaint. But we've worked very hard to accept the pleadings as true and to create for the court a pure question of law in respect of the investment contract issue, and I think as Mr. Schwartz will say, in respect of the wallet and staking issue as well.
Okay, and perhaps that's where these factual discussions are going to be had with greater detail. I guess I'm asking, and perhaps it's too much to ask of you, like right now as you're sitting here, are there factual disputes? Are there things that you are thinking to yourself, the commission completely got it wrong, and if Fela would only look at the underlying documents, she'll realize that they got it wrong? Or, and maybe that's really, to me, the disputes were most acute and pronounced in the discussion of the wallet and the staking programs. But if, for example, in other areas, there's something that you want to call to my attention, please tell me that now.
I think the answer is no, Your Honor. We talked, for example, about paragraph 65 of the complaint and Asset Hub, but you have our position, and that's an example where I think there needs to be at least a jot of critical scrutiny attended to the pleadings and what they actually fairly put before the court. I listened with great interest to your discussion with Mr. Costello about the scarcity potential in commodities and having failed to get a complete set of baseball cards many times as a child. I can tell you that certain cards are always withheld to create scarcity and drive value. Whether that's a factual issue, I don't know, but we aren't going to accept, for example, without a fight, the idea that things like Beanie Babies and Star Trek memorabilia and baseball cards aren't part of an ecosystem, to use Mr. Costello said. I think that is fair ground for debate. So I don't think that's what the court was alluding to, but we could join issue on something like that.
I'm grateful that we're all not taking the tangent of thinking about our favorite collectibles and using those. But I appreciate that. Thank you. Okay, before I started or resuming discussions of the legal issues, I wanted to make sure I understood where the parties agreed or disagreed as to the conduct. I mean, just in that vein, sir, there's a lot of discussion about what Coinbase supposedly does or doesn't do, and in particular, in your answer, your client and you, by extension, are extremely careful in parsing each allegation of the complaint to let me know what you agree with, what you are disagreeing with, but it doesn't really matter, what you're absolutely denying. And I appreciate knowing that. I am just wondering about the degree to which that matters for this motion. And my sense, the more I speak with you, is that it really doesn't.
But I think it does not matter critically. We agree. And that's because I think this really can be boiled all the way down to the question whether the sale on a secondary market in a blind bid-ask transaction of a token where no rights or obligations travel as part of that transaction can be an investment contract, as that term appears in the statute and in the case law, on the strength of the statements of intent or promotional statements that issuers have made. I think the case, at least this branch of the case, boils all the way down to that.
And on that point, my understanding of my conversations with Mr. Costello is that he believes that Coinbase is just being a bit too literal or too centurion about what that means, and that they're not suggesting it needs to be a written contract or a formal document, and you're not suggesting it either. What he's saying is, though, that there is an implicit relationship, an implicit agreement, or at least accession, by the purchase of the crypto asset in a situation where there's discussion or a lot of submissions or I guess white papers and such on the part of the developers to what's going to be done with this crypto asset. I think you're saying to me, unless there's some mechanism of enforcement and all of that very lovely promotional and marketing language, it just doesn't matter. Do I understand that correctly?
I think that's fair, Your Honor. I mean, to give even a little more ground, because we want to make, for purpose of this motion, our position capacious, there has to be, in the transaction that constitutes the sale of the asset, there has to be at least as part of that offering, there has to be a statement that is meant to convey an enforceable promise. That's the irreducible minimum of what could be conceived to be an investment contract, knowing that we're talking about contracts in the securities law context. If you don't have that, then you don't have a contract of any kind anywhere in the vicinity, and therefore you don't have an investment contract. And here again, I would keep coming back to the real estate cases, where you had all sorts of blandishments and suggestions about what was going to be built out. And the courts, one after another, said not enough. I talked about Deleuze and Rodriguez. The Reback case in our circuit is of a similar ilk. It didn't go off on the investments of the efforts of others element, but rather on common enterprise, but insisted on collateral agreements. It insisted on collateral agreements, finding none. The Second Circuit rejected the investment contract claim. So we don't think it's fair, reasonable, or sensible statutory interpretation to say that you're insisting on too much when you're talking about an investment contract to look for a contract. And the SEC has said that itself more than once. The Supreme Court has said that itself. These cases all come out the same way. And what's marked here, in our judgment, Your Honor, is a departure. We've been criticized a little bit, I think, from our friends at the other table for saying the rules of Howey and its logic and reasoning don't apply to crypto. I think the shoe's on the other foot. I think what's exactly being promoted here is a view of what an investment contract is and has been understood to be under the cases and within the statute that's completely different than has ever been the case. It is not we who are unwilling to faithfully apply that statute and that case law. It is the Commission. They are trying to stuff these transactions into the investment contract rubric when it's perfectly plain from the words of the statute and the decided cases and the chair's statements that they don't belong there. We think that's what's happening. And it's a really important issue, because at the end of it, agencies have authority, and the Commission has broad authority within the world of securities to regulate, but it does stop at the water's edge. And if it doesn't, one is casting about for a limiting principle. And I think the court has cast about for a limiting principle. We can talk about that as well, but I don't actually think the court's heard one. And I think it's a very big problem.
Well, actually, that you're anticipating my next question. You've obviously been paying attention. You saw my lengthy discussions with Mr. Costello and the concerns that I had and my requests for a limiting principle. He's given me some. You don't accept them.
Well, a couple
because they're not contract-based.
Well, you asked for a limiting principle with respect to whether private plaintiffs could bring suit, and I don't think you did get one. I think you were told that they could.
Yeah, I think that was what I was told.
So that request for a limiting principle was met with the response, no, thank you.
Well, no. Let's be. We'll both be fairer to Mr. Costello. What he said was that it wasn't by itself, and to the extent I'm thinking of it as sort of an opening the floodgates to letting all of this in. The putative private plaintiff would still have to satisfy the securities laws. There'd have to be some allegation of a purchase or a sale or fraud or something big, warranting rescission. So I accept that I overstated the amount of private plaintiff actions that could be tied to my decision in this case, although there are some. He's at least admitting of the possibility there are some. So yes. So on that limiting, I have a limit. It's just it's rather expansive, but I have a limit. The bigger issue, and the issue with which I was discussing with Mr. Costello, is my concern about this idea that simply looking at the promotional materials of an issuer somehow makes the transaction an investment contract. That purchase with knowledge of or with reading of these materials makes it an investment contract. What I was told, I believe, and he'll tell me in his summation part, is that it's more than that, and there has to be some sense that someone is buying in to the ethos or the ecosystem of the issuer by purchasing that token. Now, that may get them through 12b6. Who knows what happens at the Rule 56 stage? But that's, I believe that to be the limiting principle that I was given. I'll ask you to tell me whether I misheard and whether it's enough.
Your Honor, I think you did. We heard the same thing, so
Okay.
I do think that that's the Commission's position. That's how we understand it, and we don't think it's enough. We don't think it's enough for a couple of reasons, which I'll try to summarize. The first is we're deeply unpersuaded that it is or has been shown to be an actual limiting principle.
That was good for Coinbase.
The idea that by purchasing what is, after all, just an asset, one buys into the ecosystem can be said about very nearly anything, because nearly every commodity of value, nearly every collectible one can imagine has an ecosystem around it. It doesn't really tell you whether you're in or you're out. And I want to circle back to the question of the conceptual and the practical implications of this. So I'm going to jump on that before I shut up, if that's okay, Your Honor.
Go ahead.
But what I wanted to say before getting to that is we've offered two limiting principles, and we don't think they're parsimonious. One is that if it's an investment contract, there needs to, at least to be the offering of something that's meant to be a contract. That seems fair. We've also said that a further limiting principle is that the investment needs to be in the business. And I think the Commission allied that point by saying it needs to be an investment in the ecosystem. But I don't know what that means. It means a statement of affiliation with it, perhaps. But let's be clear, at least on the secondary market, which is all we're talking about, Your Honor, no one is giving anything to the promoter. Period. Full stop.
Fair enough, but Justice O'Connor says in Edwards, profits means the profits the investor seeks on her investment and not the profits of the scheme in which she invests. How do you square that with the argument you've just now made to me?
I think it squares well, Your Honor. I want to talk about Edwards a little bit because to state what I'm sure the Court is fully aware of, Edwards was a case in which the 11th Circuit found that an investment contract could not be had in circumstances where the investment contract promised a fixed rather than variable return. That created a circuit split.
Right.
In retrospect, anyway, it's a peculiar holding, given that it's pretty clear that the securities laws reach fixed income investments. So the Supreme Court reversed. The question before the Supreme Court was this: is the profit or the payout that has to be available in the investment contract context one that is tied to the profitability of the enterprise? And the answer to that question, stated that way, was no. And the reason was, is even if the Edwards business wasn't terribly profitable, or it was less profitable or more profitable, a fixed return could issue. It was okay to have a fixed return in the context of an investment contract. That's what Justice O'Connor was saying there. I appreciate that plucked from that context, that appears to suggest something else, but it is not consistent with the rest of that decision, as I'm sure the Court has seen. And I would remind the Court that in the Edwards opinion, the Supreme Court went out of its way to say, this is just the way the SEC has been interpreting this all the way along. And, Your Honor, we looked at our second slide about what the SEC told the Supreme Court was going on with an investment contract, including a contract which is an agreement between several parties. And it's really important because Justice O'Connor was saying you can get a payout in an investment contract scenario that is not commensurate with the profitability of the enterprise if the contract is so structured. But it was not saying that the profit or payout could be untethered from the capital structure or invested proceeds in the company's simpliciter. That makes no sense in the context of that case or the long, long line of Supreme Court cases that preceded and followed it.
All right, but I feel like we're talking about two things. You're talking now about tethering to the capital structure, and earlier we were talking about the rights of the putative purchaser to enforce. Help me with that, because I think they are two different things, yes?
They are two different things, though one of the truly fascinating and head-hurting parts of this case is the more you think about them, you see real points of intersection. So, but the answer is yes, they are.
Okay.
There are at least two very distinct ways of holding the problem up to the light to understand how to think about Howey and the contractual provision. And I do think the relevance, the reason, Your Honor, and with apologies, the reason I addressed Edwards in that way is I perceived the question about that statement to go to that issue, but perhaps wrong.
So you're absolutely, no,
Yeah.
you've not misunderstood anything that I've said. I just thought it was interesting that we ended with the discussion about tethering to the capital structure when we began sometime earlier with discussion about enforceability. I wonder if you could pause for a moment, sir, and talk with me, not to me, about the decisions this past year from Judge Rakoff and from Judge Torres. And why don't we all just stipulate, lest we be accused of either complimenting or criticizing them unduly, that these are hard issues. And maybe they came out differently, maybe they didn't come out differently, maybe the decisions can be reconciled. But I want to, for example, with respect to the Terraform decision, and in particular the motion to dismiss, I think there was some discussion about the need for some sort of contractual right, and I thought that Judge Rakoff wasn't really feeling it, as it were. But I acknowledge that Terraform is quite different from the facts of this case. Separately, I myself, I'm following Judge Torres' decision, and it's on very difficult subject matter. Although I think I tripped when I got to the primary secondary market transactions distinction. And when you began your discussions with me by talking about the blind nature of the buys and sells here, I thought, I have to remember to ask him about that and how, what importance he ascribes to that distinction that Judge Torres has found in her decision. So that's a very long question. I'll try and do better this time around. Let's start with Terraform. Is Judge Rakoff right or wrong?
Ooh.
I don't know.
Okay.
It's a very different case. I think we disagree with meaningful aspects of Judge Rakoff's analysis. There's a big however, which is...
Right, because he then finds, I thought he found that the asset was not itself a security, but it could, the asset was not itself an investment contract, but could be used in an investment contract.
I do think that was part of what Judge Rakoff was saying there, and though we would probably disagree with certain aspects of his holding out of view, when you put the decisions together, the motion to dismiss and the summary judgment decision together, we think even if that motive analysis were applicable here, our motion here would survive. And let me say why. But the Terraform case, first of all, as I know the court knows, did not involve secondary market transactions. There were no secondary market transactions in that case. The SEC went out of its way to tell the court that it wasn't dealing with secondary market transactions. Those were all situations where there was a relationship of privity between the investor and the promoter. It's a very important point of distinction. The Judge Rakoff said ultimately in Terraform, and I think I have this right, that no formal contract was necessary to form an investment contract. Fine, we agree with that. What's required in our judgment is a showing that the promoter held out the promise of something meant to convey a contractual promise. But Judge Rakoff does allow as follows, and I think these are his words: an investment contract at a minimum requires the contracting parties to agree or scheme together that the contractee will invest in the contractor's profit-seeking endeavor. Now, that would probably be a point of disagreement between the way we're framing this matter and are litigating it to Your Honor, and the way we think it's going to be rightly decided in Judge Rakoff, but we can live with his formulation. And the reason is that the SEC in this case hasn't alleged anyone agreeing or scheming together to invest in the contractor's profit-seeking endeavor. The allegations here show no agreement of any kind as between these trades on the secondary market between strangers to invest in any contractor, that is to say promoter's business. And there's still less is there any kind of agreement that the buyer's payment would be invested in that that business. So that's one point I really wanted to emphasize about Terraform. A second is moving to the summary judgment ruling. The texture of that decision seemed to us to be quite a lot different. And while the court did enter summary judgment on the investment contract issue, it did so, first of all, on the basis of recognizing some contractor-contractee relationship, which I just said. And it also went out of its way to emphasize that there were ongoing relationships and obligations with respect to the token. So as to the UST token, which is the dollar denominated, the dollar pegged token, the court relied on the fact that the token could be deposited into the Anchor protocol and earn pro rata interest or dividends, thereby demonstrating that that investment was one that was in the ongoing enterprise. As to Luna, the court relied on the representations of the company that the token carried a claim to a distribution of transaction fees, again, proceeds coming from the enterprise to the investors in a relationship of privity. And similarly with the Mirror Protocol token, the court found that it earned fees from asset trades. And so we might have a lot to quarrel about with Judge Rakoff's decision, but the truth is we can live with its analysis because it recognized ultimately that there has to be a contractee-contractor relationship, and there has to be some ongoing engagement with the assets of the enterprise. Nothing like that's alleged in this case, Your Honor. So that is the way we're holding the Terraform case.
That was strong.
Could you then speak to the Ripple case?
Well, Ripple starts with the correct first principles. Judge Torres says digital assets aren't securities, and then it goes on to analyze whether the various transactions are investment contracts, and there, as here, the question whether a security existed was strictly a matter of an investment contract. And what it found, what the court found in Judge Torres' case, was that applying Howey to secondary market trades could not give rise to an investment contract. That was what Judge Torres found. And now, we don't think all of the same arguments were raised here as in that case, but the critical takeaway there is that Judge Torres recognized that secondary market token purchases of XRP were not investing in Ripple. And in that sense, it rejected what I think is a core portion of the Commission's argument before the court today, which is its investment in an ecosystem, at least with respect to transactions between strangers where no relationship exists, where no obligations travel. That couldn't be said there, and it can't be said here. Ripple couldn't make any promises to those people because it didn't even know who they were. Same here with each of the 12 tokens it issued. These are blind bid-ask trades, and therefore, as a matter of law, Judge Torres held, and we think correctly on this, investment contract law didn't apply. These trades couldn't be investment contracts, and therefore couldn't be securities. And we think that branch of the whole thing, which was determinative in that case, as to the trades that are issued here, secondary market trades, it's a very close cousin of the issue right before the court.
Oh, yes, I understand that, and I think that's probably why the Commission disagrees with it so much. The issue here, I'm not disagreeing with your recitation of it. I guess I'm not familiar with, in other aspects of securities laws, in other cases that I've had, where the primary-secondary market distinction holds so much force, and where the notion, or indeed the fact that it's blind bid, blind ask trades matters so much. Am I wrong, or are there other areas of the law where it really does, where it has similar import? Here, I just don't remember having to focus on this in other securities cases I've done.
Thank you for that question, Your Honor, which is it goes right to the heart of what's interesting about this. Because let's talk about stocks. Stock, they trade in blind bid ask all the time, and no one would think to say it's not a security. A stock reflects an interest in the permanent capital of a corporation. And when it trades, that interest in the permanent capital of the corporation, which is a participation in its capital structure, transfers in entirety from one holder to another holder. Attached to a stock are a bundle of rights: inspection rights, right to sue, right to dividends, right to dissolution, all that good stuff. They transfer in their entirety from one seller to the other seller. And therefore, in every case like that, the issue doesn't come up because it doesn't matter who holds it. They hold the same bundle of interests, the same claims against the same entity, insofar as they are just trading interests in permanent capital. Much the same can be said about what trade commonly as notes or bonds. Investment contracts are different because investment contracts are assets stapled to obligations. And the relevant question in every case is going to be whether with the asset travels the legal obligation. You don't need to ask that question in the context of a bond transaction, Your Honor. It does. You don't need to ask that question in the context of a stock transaction. It all travels. These are different, and that's why. And it just won't do, given the requirements of an investment contract, we don't think, to say that it's the same transaction on a secondary market as on a primary market, because whatever may have traveled with respect to the ICO is not likely to travel in a secondary offering. But what matters for our motion, Your Honor, is it's not alleged to have traveled. And no one can say that in the context of a bond or stock sale.
We've had thoughtful discussions for a while now on the idea about the need for a contractual relationship and an ongoing engagement with the assets of the enterprise. I think in another section of your briefing, a distinction that you draw or an argument that you make is that an investment contract must share the essential attributes of other securities. I assume that that's just a variation on the theme, and that what you're saying is, for example, that you have to have something more than ownership of the asset. Perhaps you have some interest in the enterprise, perhaps you have something else. But I do want to make sure, when you're talking about essential attributes, and that is your argument, is that something different than what we've been talking about? And if so, what are the essential attributes that you think I should be looking for here?
I think what I'd say in response to that question, Your Honor, is first of all, and one looks at the definitional provision of the 33 and the 34 Act, the 34 Act as is relevant, I guess, with the 12 that we're talking about now. There are a list of securities. Investment contract is one of a bunch. And each one of them is an instrument that carries the legal entitlement to the proceeds, assets, or profits of an ongoing business enterprise. And so part of our argument is that investment contract should be understood to be consistent with that recitation, and that is what, in the words of the statute, makes something commonly known as a security, as opposed to buying the output of what a company makes. It's the difference between investing in Beanie Baby Inc. and buying Beanie Babies. It's the difference between those two things. Additionally, we call attention to the Judge Posner's Walls decision, which I'm pretty confident was picked up in the SEC's briefing in the Edwards case.
We talked about it earlier.
Yeah, and it talks about the essential attributes of a debt or equity instrument. And that, it's the same point, we think, but it's something different than the output of a company. It's debt, which is a senior contribution to a capital structure that is put to work by the company, or equity, which is the residual claim that is junior in the capital structure. And the things that are now being forced into the investment contract, we think are different because they play no part in the capital structure and they carry no claims against the ongoing enterprise and carry no contractual rights at all.
Just one moment, please. Thank you.
This is a very interesting argument, by the way, this idea that a security has something additional rather than just holding the asset, that there's some kind of right that goes with it. That's very interesting. We're still on the line waiting for them to obviously talk here again. But
in the interest of transparency, as I was taking my notes over the weekend for this conference, I can't define when precisely I was typing this up. One of the issues that I had was that I believed it was difficult for you to argue, for Coinbase to argue, that a crypto asset purchaser has merely a hoped-for increase in the value of the asset itself. Because to me, that to the extent that the purchaser had a hope for an increase in the value, it was because of the efforts of the developer or the issuer. And I think what I'm understanding from our discussions this afternoon is that you're not disputing that as far as it goes, but for you, for your client, the issue is that there is missing, or at least missing allegations of some sort of way of enforcing that hoped for increase in the value of the stock. And similarly, that there is no manner by which the purchaser remains engaged on an ongoing basis in the assets of the enterprise. Am I understanding that argument correctly?
I think that's fair, Your Honor. I think it's fair.
Or tell me that I'm overstating your hoped-for increase.
I don't think our argument, at least for purposes of this motion, is really fighting about whether someone's hoping for the increase. And we appreciate that the Commission has alleged that there were statements made that someone might have thought, if they were followed through upon, were going to lead to the increase. For purposes of today, we'll accept that. But it's not enough to make an investment contract. And it's not enough as a word of simple English when you think about investment contract, but it's not enough under the cases. It's not enough because, and here again, just to bang this drum, when you look at the real estate cases, you'll see they're very similar. And Judge Boudin has an analysis that says at some point, if the promises are enough and they seem enforceable enough, you might have an investment contract, and that's the holding of Duluth. There has to be something that is held out that's enforceable. That's what case after case after case says, and it's what's missing here. And it's really an important issue because there is no limiting principle of it applies. And that's because the vast majority of of investments are going to be accompanied by someone saying something. But they aren't all securities. And the question is, what is and what isn't? You could have a situation where it isn't enough for the Commission to say, trust us, we're not going to use this authority except when it makes sense. Because that can lead to a company thinking it was complying with the securities laws and then being on the receiving end of an enforcement action. That's a familiar scenario for us. It could also lead to any number of businesses believing they're operating with, essentially in dealing with what are non-securities and finding out that they're not. Because every commodity has promotional statements around it, and they aren't all securities. And what makes it different is the contractual undertaking that gives an interest in the business. If you don't have that, you don't have a security. So I'm sorry for the long-winded answer. The short of it is, you're right that we accept that there is an investment, and someone might think the promotional statements might, if acted upon, give rise to an increase. Our position is that's not enough, that the cases say it, and they say it over and over again.
Where is this in Howey? I mean, I understand from the securities law scholars that the precursors, the state law antecedents to Howey, speak about this, or at least they arose in that context. But the actual definition doesn't itself speak of this, either this contractual relationship or this obligation or means of enforcement or the ongoing engagement. So I don't know where it comes from, and I'd like to know where you're slotting it in the Howey test, if anywhere. And so let's start with that.
Yeah, well, it's a fair question. Howey only applies to instruments that constitute a contract, transaction, or scheme. And one answer to Your Honor's question is it's none of those things. It's not a contract. It's not a transaction. It's not a scheme. And we've talked about how it's not a contract, and we've shown, I think, that it's not a scheme as that phrase was understood in Howey. It is true that we have chosen in our presentation to the court to not reduce Howey to 3 elements and then ritualistically go through each of the three elements. And
Right.
we did that for several reasons. One is that, as I mentioned earlier, there's a great deal of intersection between the issues. For example, the need for a contract came up in the context of a collateral agreement in REBAC in the discussion of the common enterprise, but it came up in the other circuit cases in the context of the reliance for profit solely on the work of others. So these issues cut through, but they do not appear all the time in the same place, but they appear over and over again in the Howey jurisprudence. When the Supreme Court talks about Howey, it doesn't reduce it to three elements. It looks at the instrument in front of it, and it tries to figure out whether it fits within the traditional definition of a security. A lot of the circuit court cases do the same thing the Walls case does, and Rodriguez. We would broadly say this, that much of what we say about the need for a contractual undertaking demonstrates the lack of any adequate pleading as to the generation of profits from the efforts of others, because those cases all say that has to be something that you can go and get, at least has to be promised to you that you can go acquire that. So it fits in there. And much of what we say about the SEC's failure to allege an interest in an enterprise demonstrate a failure to plead a common enterprise within the Howey factors. And that's why we cite not just Howey over and over again, which we do, but the cases interpreted.
Well, to that point, I had two reactions going in two different directions. And one was, I thought you were about to step in the trap that Mr. Costello laid for you earlier, where he discussed how Coinbase's citation to or use in any way of the Howey test undercut its major questions doctrines argument, because the idea of, by acknowledging Howey, you're as the field, the playing field on which these issues are to be resolved, you're necessarily suggesting that there isn't some void, some almost ultra-virus activity that the Commission is doing, which would implicate the major questions doctrine. So that's one thing to think about. Thing two is that I had a question to myself, which is to how your arguments applied, or was the logical extension of your arguments to be that there could be no common enterprise with respect to the 12 or 13 tokens. So we can save major questions for your colleague, who I know is going to speak to that, so she'll know to talk about that. But can you help me understand how, if at all, your arguments about the need for contractual or ongoing relationships, and I'm very much short-circuiting them by calling them just with those few words, I'm just sort of, evoking them for you, how that impacts the common enterprise analysis?
Well, I don't think it's impossible that a token could have those characteristics and satisfy the Howey test. And we said that in the abstract. We haven't talked about Judge Costello's decision in Telegram, but that is a really interesting case along these lines. It's a primary issuer case, and I want to be clear on that because it's suggested in the briefing that it's not, but the SEC was plain as day that it was, and I think the case is clear. But that was a situation where there was a contract right in the middle of the case. It wasn't anything like this, the Graham Purchase Agreement. And it provided for certainly a contractual undertaking, and one in which there were going to be payments made in tokens for the performance of the enterprise or the return of the investment if the blockchain wasn't launched. And that seemed to be a very reasoned application of all of this in the Howey prongs. It fit in a way because you were able to look at the way the funds were invested and see them pooled in a common enterprise, and you were able to see the contractual undertaking that made for the return. Many of the cases, however, that are shoehorned into the complaint and might otherwise be litigated just can't fit. And one of the things that caused us to think a little differently about Howey, Your Honor, is that in this case is that it's a unique case, and I use that word advisedly, where the SEC alleges that an investment contract changes hands on a secondary market. That's new, and it fits very, very with real difficulty analytically with Howey, because Howey was a privity case, a primary issuance privity case. Nearly every single one of the cases that followed it was a primary issuer privity case. The only one that wasn't was maybe the Hocking case, which we've talked about in our briefs. I won't bore the court with, but it seemed in the context of a secondary transaction very difficult to shoehorn a blind transaction that required a contractual undertaking into the Howey analysis, which I do think fairly said wasn't built for that. But I want to be clear, we have no fear of Howey. It's a case that says an investment contract requires a contract. It actually says that the investment contract anticipates an investor taking shares in an enterprise, and it says repeatedly that those shares are to be evidenced by contracts and deeds, and those contracts and deeds should determine the future payout due investors. That was Howey, and that's our case.
Good counter argument. That was really good.
Speaking for a moment, going back to Terraform and also Judge Barbadoro's, I believe it's called Library, LBRY, at least that's what I was told at our last oral argument. I thought I understood, and at least it's been suggested to me, that I should understand those cases to stand for the propositions that what mattered for purposes of whether these were investment contracts or whether it's securities was whether the tokens were marketed as profitable investments and whether the profits were derived from the efforts of the issuer's management team. Now, neither of your issues, either an enforcement, a means of enforcement, or a sort of an ongoing interest or relationship is present. Has the argument that's been made to me, does it just overlook important things of Terraform? You've already talked about Terraform. Perhaps Library is the place to talk.
Well, I mean, I guess I do want to emphasize that Library, if that's how it's pronounced, is a pure ICO primary trading case. And that's a very important point of distinction. And because it was an ICO case, the matter of the contractual undertaking was much easier to resolve, and there were findings there about the way those proceeds were invested to launch the enterprise. On the subject of our slides, I'll just draw the court's attention to slides 10 and 11, and we think this is really important because we don't think these cases, which had only to do with the ICO context, the initial offering context, the primary privity context, can be imported into the secondary arena. In the briefing, the Commission suggests that they stand for the proposition that primary and secondary transactions ought to be viewed in the same way. In every one of these cases, the Commission stood up and told the judge, we're not talking about secondary trades, they're different. Each one of them, including, as on the last slide here, 11, you can see that the judge even seemed quite frustrated about it every time he raised the matter of secondary transactions. We're not litigating that here. The Commission has to decide that, blah, blah, blah. And then the court said,
That's the transcript, huh? Yeah, that's awesome.
Right? Have I misunderstood your position? No. And so those cases, they're just not opposites here. They concern very different factual practice.
Okay, thank you. I'd like to give you a break, please, if I could turn to your colleague, Mr. Schwartz, to talk about why my discussions with Mr. Margita about wallet and staking were all wrong. Thank you, sir.
Not all wrong, Your Honor.
Okay, great.
Your Honor, we'll start just by saying that there are actually I'll start with wallet if that's comfortable. There are actually very few allegations put at issue in the wallet claim. And as you heard from our friends at the front table, the law is well settled and the parties aren't disagreeing about what it is. We both cited the same 9 factors, and I think there's no real dispute that nearly all of them are absent from the SEC's allegations. They don't dispute that they haven't purported to allege the variety of core brokerage activities that are traditionally found by courts, negotiating terms for the transaction, making investment recommendations, arranging financing, holding customer funds, conducting independent asset valuations. None of these core factors are addressed at all, even purport to be alleged. What they do say they alleged, and that's what I want to turn to, and as my colleague said, you may find it helpful to look at page 15 in the deck. This just sets out on one slide for you, so you can see the 4 paragraphs in one place that the SEC points to as sufficient pleadings to survive the motion for judgment on the pleadings. We think these fail as a matter of law to support a claim that Wallet acts as a broker. I'll point you to 64 and 82 to start. Those together talk about Wallet routing customer orders through third-party decentralized exchanges. Assets from blockchain developed a swap via Wallet, price comparisons across multiple exchanges. What you don't see in these allegations, Your Honor, are any well-pleaded facts showing that Wallet itself is doing any of these activities beyond allowing users access to the third-party platforms who give that functionality, who carry out those activities. And here, Your Honor asked about this earlier, and we want to direct your attention to it indeed. The user agreement, which is incorporated in the complaint by reference, lays this bare. The bottom line that it's not Wallet, but it's third-party platforms that are carrying out the very activities the SEC is referencing. And here, if you turn to slide 16, Your Honor, you'll see the portion of the Coinbase user agreement excerpted for you, setting forth what happens in Wallet. The app or browser provides a link to the platforms. Through the link, users, quote, navigate away from the Coinbase site to the DApp or the DEX. And, Your Honor put it very well in the Uniswap case. Once Wallet provides a technical connection to the third-party platforms, customers then direct the smart contracts on those platforms, like the Uniswap trading platform, to take the digital assets out of Wallet and carry out the swaps or whatever activity those exchanges permit. There are no well-pleaded facts to the contrary here, suggesting that these activities occur within Wallet itself. And I'll just add, Your Honor, there was an earlier colloquy about 0x, which is yet another one of these third-party exchanges. It's an information-based protocol that connects up to third-party platforms. That is not within Wallet. It's not alleged to be within Wallet, by the way. My colleagues at the front acknowledged that was noted in a footnote on page 27 of the brief. It was not alleged in the pleading. But I'll hasten to correct it anyway. 0x is one of those third-party platforms to which the Coinbase Wallet, the user interface, connects those users to do activities on a third-party platform. And that's a critical correction or clarification in light of the limits of the pleading and the user agreement that's fairly before the court. Another activity they point to in paragraph 75, you had a discussion about earlier, was solicitation of investors as something that was purportedly alleged. If you look back at paragraph 75 again on slide 15, the allegation is that Coinbase solicits customers by advertising features of Prime platform and Wallet. Advertising to download the software. That's nothing like the findings that courts have made for solicitation of investors for particular investment transactions. That's the broker solicitation courts have addressed in the cases the SEC points you to. Hansen, Martino. In the SEC's brief, those cases are ones that identified as brokers agents of issuing companies who actively targeted prospective investors to raise capital by touting particular investments. None of that is alleged here. And so here again, I think it's fair to consider solely the limits of the allegation and the absence of well-pleaded facts, adding anything of this sort to solicitation of investors to conclude that this too is not alleged as one activity. Lastly, you had a discussion about paragraph 101, the last one listed on slide 15, that Coinbase used to charge customers transaction-based compensation for the activities on those third-party platforms. Coinbase no longer does charge for those activities, but even if it did, it's important to say the courts have been crystal clear, and it's long been true, commission-based payments standing alone do not make brokerage activities. And that's
okay,
not
but in fairness, they're not suggesting that the commission standing alone would have made Coinbase a broker. They are suggesting that what you say is providing access to third-party apps, DAPPS, and things like that. That's what I guess the concern I have.
absolutely true. Yeah.
Right. So the concern I have is, you all seem to have a dispute about the facts. I think I'm hearing you tell me that I can resolve that dispute in this context because the user agreement and other statements, when compared with the paucity or the abstractness of the Commission's allegations, no offense, is enough to allow me to find as you wish me to find. But I think they're saying, not yet, Fela, you've got to let this go through to discovery.
Yes, Your Honor.
Okay.
I think that's exactly right. With respect to the allegations in 64 and 82 that we talked about, that paucity, saying that Wallet does something through third-party platforms, that something happens via Wallet, that the price compare happens on us, each of those is the circumstance you just described, where the paucity plus the user agreement gives you ample basis to decide the pleadings don't suffice. But where I'll round out the picture is with respect to the solicitation of investors, the only other core broker activity the SEC claims to have even alleged, that on its face does not allege what is understood as a matter of law to be the solicitation of investors by brokers.
I see. I appreciate the clarification. Thank you. Let me just take a note of that.
This isn't looking good for the SEC so far. Full summary, obviously, over at ehack.com. We're waiting for the judge here to keep talking and ask our next question of Coinbase, then we'll get to summary arguments.
Your Honor, in case useful, it occurs to me from your discussion, one way that the SEC has sought to suggest there's an alternative frame or some different version of facts is by saying the user interface connects and therefore facilitates,
Yes.
it puts these parties together. Again, this is not a fact dispute. As a matter of law, that facilitation or putting parties together does not make brokerage activity. And I'll point Your Honor's attention to a case in our briefing, the Reed case. This is also found in the Foundation Ventures case. But Judge Lyman in the Reed case made clear merely providing information or bringing two parties together to make their own contract does not transform an individual entity into a broker, even if they receive commission-based payments. At most, it's the activities of a finder, and that is not subject to the securities laws. In that case, the person at issue didn't negotiate the transactions, didn't engage in substantive conversations, give valuation advice, the variety of core activities I mentioned that aren't even purported to be alleged here. And so,
Fair enough, sir, but I think the concern of the commission, and it might be a concern that I share, is to the extent that what we're talking about is how you can implement technology to make things faster, easier, have access to even more entities. There's a concern I believe the commission has that it can't just be that technology obviates a finding that one is a broker, because if what you do, if you do broker-y functions, but you do them through some sort of automated mechanism that you have at your disposal, you might still be a broker. I think that's what the commission is saying. I think what you're saying, and let me just confirm that, is that the allegations that are contained in the pleadings, as amplified or perhaps given further detail by the user agreement, are just not enough. Am I understanding your argument correctly?
I think that's exactly right with respect to those activities that the commission claims to have alleged.
Okay.
And there's no dispute about the variety of core activities they don't claim to have alleged that I mentioned at the outset.
Right. So there are a number of factors that I may consider in determining whether someone is acting as a broker. You're saying they don't allege all 9 or whatever; they allege a couple, and as to those, there are reasons to disbelieve or to view with skepticism the allegations that are made.
Yes, we would say there's reason to find they're not well-pleaded facts to support those allegations.
Or that. Okay. Thank you. Shall we then speak of staking, sir?
Yes, absolutely.
Are there slides about staking?
You better believe it, Judge.
Okay.
I will turn your attention. In fact, I hope it's helpful. Slide 17 was designed late at night, bearing in mind and reflecting on the last time we all gathered. And so I'm very glad to give it some attention. Your Honor asked a question, about what's properly before you when it comes to staking back in July. And that's why we thought it might be worth stepping back to frame what is properly at issue in the pleadings when it comes to the staking product. And to be clear, we think there are 3 different reasons, each sufficient on its own for this claim to be dismissed. But I'm going to start with the investment of money. And let me frame this for you. We've set out here the various provisions from the allegations in the complaint and from the user agreement, which we think suffice to give you the picture of the facts that are relevant for disposing of these pleadings. At the foundation of the blockchains is the need to validate each new block or transaction that's added before it's added to ensure the security and accuracy on a consensus basis. You can see that in paragraph 312. Where staking comes in, Your Honor, is from two propositions, again, set out in the sources before you. Number one, blockchains that use proof of stake to achieve the consensus I mentioned set a fee, they call it rewards, that they pay to token holders to perform this critical validation service. That's set out in paragraphs 312 and 313 of the complaint. Number two, the users who take on this validation service to put up or stake some of their tokens while they're performing the validation service they get paid for. Paragraph 313 calls these staked assets collateral. Collateral against improper validation and collateral that's held in the protocol while the services are being carried out. For token holders who stake on their own, Your Honor, that's it. It's a fee for validation service for the blockchain, and you can identify that, again, in the allegations before you, confirmed by the provisions of the user agreement. Some users then choose to subcontract that service to Coinbase. They hire Coinbase to operate the IT to validate on their behalf, and they direct Coinbase to stake their tokens on the blockchain while that happens. Those are the facts from the complaint and the user agreement. And with these in hand, we think you can turn to each of the two reasons. We'll start with the investment of money, of why the complaint fails to plead an investment of money under Howey. And I'll begin, Your Honor, just with a case that the SEC, emphasized to you, the Ribera case from the Ninth Circuit. The Court of Appeals there said one has to, quote, commit assets to the enterprise in such a manner as to face the risk of loss. And I want to focus on the first part of that. Commit assets to the enterprise to have an investment of money. Sounds straightforward. Without a contribution of assets to the capital structure, there's just no investment. Here, the SEC has made no allegation. There's no plausible claim that they could, that staking customers commit anything to Coinbase in this way. They just direct Coinbase in the normal custodial relationship to make their tokens available to the blockchain as collateral, paragraph 313 puts it, for potential slashing for error validation, and to provide IT services in connection with it. Now, the sole way that the SEC tries to satisfy this commitment of assets requirement, I'll point you to slide 18 for this, just to put their allegation in front of you. Paragraphs 340 and 341 and repeated elsewhere, is to tell you staking customers tender and just give up control over their tokens to Coinbase. And, here going to your question earlier about, where something is wrong but properly before you to resolve, center stage, Your Honor, this bare allegation warrants no credit and it's contradicted by the user agreement. You can see on the next slide, slide 19, section 2.7.3 of the user agreement and the appendix, which establish you, the customer, control the digital assets held in your digital wallet, and Appendix 4 extends this to staking services, whether or not the digital asset is staked. And this is important, in granting a motion to dismiss the Underwood complaint against Coinbase, Judge Engelmeyer addressed the same user agreement. And much as Your Honor described earlier, said where a document is incorporated by reference, the court need not accept contrary allegations in the complaint that seek to elude the facts contained in the incorporated document. His words were, the user agreement checkmated those plaintiffs from adequately pleading their claims. And, Your Honor, you won't be surprised to hear, we think you should likewise find the SEC's bare allegations that customers give up control over staked tokens in order to claim there's a commitment of assets. It's checkmated by the user agreement. And taking that aside, there are no well-pleaded facts suggesting that anything about this relationship, this fee-for-service relationship that users have with the blockchain and they subcontract to Coinbase, there is no commitment of assets. There is no contribution of capital by the users to Coinbase's capital structure that could possibly satisfy the investment of money requirement that Ribera and courts have long required. Another aspect of staking you asked about, Your Honor, unless there's a further question about that, is risk. We spent some time in colloquy about risk. And that goes to the second half of the Ribera, of the sentence from Ribera, again, that the SEC is trying to rely on.
Well, are you suggesting that it's wrong for them to rely on it?
No, I think it's the right case to rely on. It just doesn't help them. Unfortunately, their allegations fall short of that standard of law. And here again, I'll just quote you the back half of what we said. An investor must commit his assets to the enterprise in such a manner as to subject himself to financial loss. And it's not just the Ninth Circuit. The Second Circuit has affirmed that the Supreme Court added this limiting requirement as well. Now, on slide 20, Your Honor, you'll see the handful of paragraphs that the SEC tells you suffice to allege risk of loss from staking. And I'm happy to take you through them. I'll tell you broadly speaking, apart from the conclusory allegation at the top, the first two, 341 and 343, concern blockchain requirements for staking and validation. The bottom two don't concern staking. They're just risks that are general to token holders. Both buckets of these allegations fail as a matter of law to assert risk of financial loss in the commitment of assets to the Coinbase enterprise.
Let me ask you to pause for a minute, sir. I've spoiled myself a little bit by looking at the next slide, it's slide 21, which speaks about the risk of loss and how it's discussed in the user agreement. My reaction to reading the briefing was that I thought that Coinbase argued in a number of ways that the risk of loss was infinitesimal, or that the risk of loss was something that could be addressed or made up for by Coinbase if anybody lost money, or that the risk of loss was the same if you were self-staking, or that the risk of loss was something that you'd have just as a customer of Coinbase, irrespective of whether you staked or not. But all of those arguments, they sounded to me a little bit defensive because they all seemed to presuppose that there was a possibility of loss. If the Ninth Circuit test that we're saying is the right test to use is that the risk of loss is itself enough, then the fact that the risk of loss is really small, could be made up, or it could happen in other circumstances, I'm not sure it gives me a complete answer. Can you help with that?
Thank you for the question. It covers the waterfront really well, and so let me try to take it in a few pieces if I can. Let's distinguish the two buckets, if you will, those that relate to staking in some way and those that don't. Because I don't think we would say that the risk is just so small you don't have to worry about it. The risk of loss does not exist on the pleadings and the user agreement before you. The first risk they point to is slashing, Your Honor, this idea that there could be improper validation and the staked assets are slashed. But that same paragraph, 343, acknowledges that is not a risk that Coinbase stakers face. It doesn't say it's small. It's not a risk that Coinbase stakers face because Coinbase indemnifies for it. Now, they go on to say there's still general risk. I'll just flag for Your Honor that quote in the rest of 343 is from a money transmission disclosure that Coinbase has for New York State, where paragraph 333 of the complaint acknowledges Coinbase does no staking business. So that quote has nothing to do with staking. So there's a discussion about slashing risk. Coinbase indemnifies for it. The allegation acknowledges that risk does not exist. The second risk that's talked about in 341 is a risk of loss while staked because tokens can't be used for other purposes like trading or transferring. And here again, this is just restating a condition imposed by the blockchain that the validators who choose to sign up for this service and perform this service for the blockchain in return for a fee put up collateral while they're doing the service. Think of it something like a security deposit. They're not going to do a bad job. They're not going to make mistakes while they're there. They get it back at the end. There's the allegation of risk that they can't do other things with their collateral, their security deposit. Doesn't state a risk of financial loss that Rivera was talking about in such a manner from your investment. The last two, again, I think Your Honor summarized it very well. 344 and 345 are just not staking risks. They're risks alleged for anyone who holds tokens. Now, the way the SEC frames that as a defensible and sufficient allegation is to say that there's a risk of ownership loss for all token holders, and they don't have to allege more. And I want to tell you why that's wrong, Your Honor, but first, as you saw in the briefing, we do take issue with and dispute that standard of law. That's exactly what courts have to show is that investors put capital into a business with the risk that its performance may lead to their inability to recover the capital. That's what investing in such a manner to face the risk of loss is, according to Rivera. And, stepping back, here the SEC is charging Coinbase with offering an investment contract through its staking service. To have an investment of money that's required for that, there has to be a risk of loss alleged that arises from staking through Coinbase. But even if that's not necessary, and Your Honor says, well, what about their risk of ownership loss? You can see on the slide, as you jumped ahead to slide 21, there are no well-pleaded facts here stating a risk of ownership loss over stake tokens. My friends at the front table say that's our say-so. It's the courts say-so over and over again. For a custodial validator like Coinbase, ownership over staked assets is dictated by the contractual agreement between the user and the custodian. You can see in these provisions we've set out for you, Your Honor, this user agreement is crystal clear. Title to staked assets at all times remain with the users. They do not transfer to Coinbase. They don't become property of Coinbase, and they don't become subject to general creditors' claims under any circumstances. And these guarantees are obviously very important that the tokens will be returned. I want to point you to one more source, Your Honor, your colleague Judge Engelmeyer, who recently confirmed this very point that I'm pressing to you as a basis for the inadequacy of this claim. He examined whether title had passed to Coinbase in any respect in the Underwood case. And he granted the motion to dismiss based on the user agreement, finding, quote, the user agreement's terms flatly contradict the allegations that Coinbase holds title to the digital assets. Appendix 4 says the same thing for staking services. They do not affect ownership. Taking that on its face, Your Honor, this is an independent reason why, as a matter of law, the complaint fails to plead the required investment of money bearing a risk of financial loss, and the claim should be dismissed. We think that does resolve the staking claim.
Well, you're saying it's an independent reason, and that's because the first reason is because these aren't securities.
Well, the first reason is there's no investment of money in the capital structure.
Okay.
And second, in any case, there's no risk of financial loss well pleaded in the allegations. The last aspect of staking, I'm happy to, Your Honor, if you'd like to discuss it, although mindful of time, I'll respect if you've heard enough about staking for the day, is the efforts of others that you had some colloquy with our friends from the front table as well.
A little bit of the efforts of others, I guess it seems that there's not necessarily a disagreement between what activities or what services Coinbase is or is not affording to these to folks involved in the staking process, but whether those amount to ministerial or managerial.
For the most part, I think that's right. I'll offer one clarification. You can see on slide 22, we tried to group the various activities from Coinbase that the SEC alleges as efforts of others. The reason I offer an asterisk to that otherwise apt description, Your Honor, is the first few categories do not concern Coinbase's activities or those that are alleged to be managerial. The first category, the group of paragraphs, concern general proof of stake activities, not about Coinbase, and so it's not about Coinbase's efforts.
Fair. Okay.
The second is about retaining third parties to stake assets. Again, not about Coinbase, not Coinbase's efforts. The third category is about liquidity pools for quicker withdrawal. Something that's acknowledged in the complaint is no longer the case in Coinbase staking, but in any event, again, on its face, addresses the administrative convenience of unstaking, of exiting the staking program. It doesn't posit any managerial qualities or otherwise in the conduct of the actual staking program at issue. So those first three, I'll just say, are actually separate. The bottom two are, the remaining efforts the SEC alleges, and quite as Your Honor put it, those just aren't the type of aren't the type of managerial and entrepreneurial efforts required by Howey. They are just the type of clerical and routine functions that courts have found do not suffice to plead the requisite standard, the material, significant impact on returns. That goes for the IT services with software and equipment. That goes for the pooling, where there's an aggregation of tokens to stake. And, we direct Your Honor's attention to the Life Partners case, where what was found to be ministerial, Your Honor, was an almost identical constellation of efforts that was found to have, quote, no material impact on the profits of the investors, including because these were services that, quote, anyone, including the supposed investor himself, could supply these services. and there were a number of others who could have as well. So, again, happy to delve into it further, but we would commend those excerpts from that we put in front of Your Honor from like partners to lay bare quite how clear it is as a matter of law that we think the back office, mechanical, outsourced IT services and administration that's alleged in those bottom two categories of paragraphs do not rise to the level of an adequate pleading of efforts of others.
Thank you so much. I think that leaves me with Ms. Eddy and the major questions doctrine. Ms. Eddy, one of the discussions I was having with your colleague, Mr. Sabat, was the reconciliation, if there needs to be one, between Coinbase's arguments about the applicability or how it interprets the Howey test and how that works with the argument it's making about the major questions doctrine. So perhaps we could begin there. Could you help me reconcile those two ideas? And what I mean in particular is, to the extent that you are arguing that the Howey test applies by its terms, that that's the test I should be using and that we should be working in that framework rather than suggesting that these particular tokens are outside of that framework, does that in any way exist in tension with your argument that the SEC's bringing of this case amounts to some sort of arrogation of powers it doesn't have? And I'll ask you, just because I know this court, to grab the microphone and bring it near you. I'm sure we will hear you, but I just know that there's something about those microphones. Thank you so much.
Thank you, Your Honor. And I will say, I'll preface this by saying our position is that our interpretation of Howey and our argument about the investment contract and what it requires fortifies the major questions position that we have. In fact, it undergirds the whole thing. We don't think you even get to major questions here because the text and the context and the precedent establish that the position the SEC is advancing here is not grounded in law. But if the court were to disagree and to find plausibility in the SEC's position, that's when the major questions doctrine would kick in and it would compel rejection of that position. And that's because, as Mr. Sabat, I think, already explained at length, the transactions on Coinbase's secondary exchange are of a different character than anything that the SEC has asserted regulatory authority over before. And they are of a different character than the interpretation the SEC itself has advanced in Howey, in its briefing there. It talked about contractual arrangements, for example. It's different than any position that it's taken in briefing since, in some of the briefs that Mr. Sabat highlighted from Edwards. It's taking a different position than Chair Gensler took in 2021 when he appeared before Congress and asked for regulatory authority to cover transactions on crypto exchanges.
Let me pause you right there for a moment, because I want to know the degree to which you're asking me to look at certain allegations in the preface to your answer that, again, to me seem to speak more of a question of optics or not. For example, I can understand Coinbase's frustration that it tried to be helpful. I mean, if that's how it perceives what it was doing. It tried to be helpful. It tried to talk to the commission. It tried to get some guidance. And then, rats, there's an enforcement action brought against it. So I get that. But for me, there's a layer of, again, optics that I'm really not considering, or at least I didn't think I need to be considering in the context of the major questions doctrine. The fact that you asked for guidance, your client asked for guidance and didn't get it, to me doesn't suggest major questions doctrine. I'm assuming instead I'm looking at a narrower universe of materials, which would be the statements of SEC officials, the higher-ups there, and the positions that the commission itself has taken in other cases. Am I correct, or am I also supposed to be looking at everybody's efforts to be helpful?
Your Honor, you're absolutely correct.
Okay.
There is a good portion of the allegations in the preface to our answer that you can properly consider and should consider, not just as optics, but as factors, as going to factors that the Supreme Court has repeatedly identified as relevant the bevy of congressional activity surrounding this very significant question of how to regulate crypto, and the fact that Chair Gensler made those statements to Congress in 2021. All those facts you can consider and should consider, we submit, and I don't think the SEC disputes that. Those aren't really facts.
No, I don't think they dispute it. I think what they say is that the Gensler statement's taken out of context, and you disagree. There's quite detailed and yet not not the same results. Everybody has a view of that, and I understand that. With respect to the bevy of congressional activity, I thought I understood the argument to be, and it's also presented in some of the amicus briefs, is that the fact that Congress seeks greater clarity doesn't necessarily mean that the SEC lacks the authority in this space. I appreciate that your view is it does, but I think their argument is we've always had rights to regulate securities, and it may have took us a moment. We may have had stumbled along the way, but we figured out how we could do it, and here we are doing it. As distinguished, I'm not sure it's of a piece, for example, with, just to pull something out of the air, like the OSHA vaccine mandate. Whatever your position is on that, I'm not sure that was something that OSHA did on a regular basis. Or the student debt cancellation, I'm not sure that's something done on a regular basis. Here, the Commission would argue, this is what we do. And yes, the token, the asset may be different, because over time, different assets develop, but it's really no different in terms of the mode of analysis that we're applying. Why are they wrong? What is it about crypto that makes it so qualitatively different than the other assets or the other putative securities that the Commission has considered and regulated over time?
Let me begin by saying that it's not what makes crypto special. It's the nature of the transaction that the SEC is now designating and calling a security, that it didn't designate or recognize as a security in any of its prior briefing over sort of the 90-year history of the Exchange Act, in Chair Gensler's comments to Congress. And this is a special kind of transaction. It's one that doesn't have an ongoing legal relationship between the issuer and the purchaser. So that is the class of transaction that is at issue here, and the SEC is offering an interpretation through a campaign of enforcement actions that is not just arrogating authority to itself, it is expanding its jurisdictional perimeter. That is, in some sense, it's similar to the Brown and Williamson case, where there was the question was tobacco a drug or a device? Here the question is this class of transaction a security? And that the congressional activity we're not saying that's dispositive, but it is something the court can and should consider under the governing precedents in assessing whether Congress has spoken clearly about whether the term security, the term investment contract, can properly be conceived to cover what the SEC is identifying and pursuing here. And I think for all the reasons that Mr. Sabat already gave, that there's no clear statement of that kind here.
I just want to make sure I understand what you're saying, because it was not the answer I was expecting, which doesn't mean it wasn't a perfectly fine answer. You're saying that what is the thing I should be concerned about is not crypto assets, what are they securities or are they not, but that the particular transaction that's being challenged, the particular types of transactions that are being challenged are so different than anything as to which the Commission's asserted authority in its history. Am I understanding that correctly?
That is the first part, Your Honor.
Okay,
yes,
that's fine. I will step
the court. And I think that the cases look both at what is the nature of the arrogation of authority, how expansive is it? And I think that's part one of the answer. The cases also look at what is the impact here. And what is the significance on the practical level of the expansion that the agency is asserting? And that's where we look at the fact that this is an arrogation of authority over an entire industry. And
but I'm sorry, the impact, I'm looking at the impact on whom? On both the industry and on the commission? Because I thought from listening to your colleagues at the front table that one of the issues that was discussed was whether, enforcements went, from something in the tens to something in the thousands or something like that. So am I looking at what this could do in terms of how much it would expand the number of enforcement actions the commission could bring, or am I looking at it in terms of the crypto industry itself?
You're looking at it, Your Honor, I think in both, but it's certainly the latter.
Okay.
And the commission does try to advance this argument that this is really just routine enforcement action and sort of incremental routine enforcement action. It is certainly true that the complaint here leaves allegations regarding just 12 tokens traded on Coinbase. But it is part of a concerted campaign against crypto exchanges generally. There were other lawsuits filed in close proximity to this one against other crypto exchanges. And it is obvious that if the court were to accept the commission's definition of investment contract in this case, that would have essentially legislative implications. It would affect the whole industry. And the commission has kind of made no apologies for this.
Please pause for a second. Two follow-up questions before you move to your next section of argument. I think you're suggesting to me that I need to look at this as sort of it's one enforcement action. It's only 12 to 13 tokens, but heaven forfend, Vela, if you let this in, there'll be nothing. We'll have nothing but enforcement actions against either folks who provide the services that Coinbase provides or crypto asset issuers in the first instance. So I guess when I'm thinking about the impact, am I allowed to think of it, as you suggest, by looking at it not merely as the case before me, but as what that case might portend?
Your Honor, and I think it is not just a matter of enforcement. I want to be clear about that too. If the court were to take the SEC's view that the token transaction, the trades over Coinbase's secondary exchange are investment contracts, then the implications of that are that the SEC's regulatory apparatus applies to crypto exchanges. The court can and should take that into account. And I know there's been some suggestion that there's an absence of authority for the proposition that an enforcement action can give rise to the major questions doctrine. And I want to just point the court, one of the amici cites this, but it's the Gonzalez case, in which an enforcement policy was at issue. And the major questions doctrine was applied there. Attorney General Ashcroft had issued an interpretive rule construing the Controlled Substances Act to prohibit physician-assisted suicide. And the court held that wasn't a regulation. It wasn't entitled to any deference of any kind. It was an announcement of an enforcement policy, and it applied the major questions doctrine to that. And I think the doctrine applies when the position that the agency is advancing is essentially an encroachment upon Congress's prerogative. That is what's going on here. Congress, 1934, listed out the instruments that qualify as securities. Investment contract is one of them. The SEC has been litigating the contours of investment contract for decades, never advancing the theory it is now advancing in this case. And that's precisely the sort of circumstance in which the major questions doctrine should be invoked and should be applied.
Okay.
The second argument you make is that accepting their position would have effectively legislative implications. Did I understand that argument correctly?
Yes, I think that's right, Your Honor. The commission deliberately, being that Congress has not acted, has not granted the authority to regulate crypto, has instead taken matters into its own hands. It has gone back and looked into the Act from 1934 and said, aha, we have the authority we asked for 2 years ago. That's impermissible. And it's impermissible because there's no clear statement that this kind of transaction fits within the definition of a security, and thus within the Commission's own jurisdiction.
I guess what concerns me is I'm reluctant to focus to view through too narrow a lens what the Commission's enforcement ability is. I think they're telling me it is routine, and you're saying it's not. So I appreciate that. I'm just saying that. I guess another issue is 10 years on the bench, no one has ever said to me major questions doctrine until this case. I understand 10 years is, just a very small drop in the bucket to many judges, but I'm sort of shocked. I've had some interesting cases and this has never come up. My read or my research into this area does not suggest that it comes up very often, and even less often does it actually get found by a court. So I'm not, I guess my question, and I mean no disrespect to your clients, but I'm just not sure the crypto industry that it is so major or so extraordinary that I need to find it here. I understand your initial point, which is, well, you don't have to if you just go our way on the other arguments. Yeah, I get that. But I'm saying I have a natural hesitation to involve or to make a finding that something implicates the major questions doctrine because it is so infrequently done. And I'm not sure this is on a par with the student loan forgiveness or with the energy industry. And I know what Brown and Williamson is. Perhaps I might have my own skepticism about the Brown and Williamson decision. I appreciate, of course, that I'm bound by it. But I guess I'd like a little bit of comfort that what you're asking me to do is, here's the tension. You're saying to me, what the commission is doing is so crazy, so beyond what it should be doing, that you need to stop them. My point to you is, it is so infrequently that, and in fact, this is the one case where I've been asked to do that I worry that I am, in my own lane, doing exactly the thing that you're arguing the commission is doing here, which is to take power I don't have to stop activity I shouldn't be stopping. So that's why I'm asking. I mean, I'm not asking you to hold my hand here, but I'm just saying there's a comfort that I need to have that this isn't as much of a nuclear option as I think it is based on the cases that I've read.
Your Honor, you spoke about your own power and the concern about stepping outside your lane. And I want to just return to a comment that you made when speaking to my colleagues on the front table about Senator Loomis's brief.
Yes.
The question here is, as between Congress and the SEC, who has the power to legislate this question? And that's I think the question that that is central to your inquiry. I do want to note, though, and just make sure the court has in mind, there are a wide variety of circumstances in which the major questions doctrine has been invoked and has been applied. And
they're two different things, right? Being invoked and being applied. So go ahead.
Well, let's talk about, I guess, the ones in which it's been applied. It's been applied to the elimination of rate publication requirements for 40% of telecom providers in the long-distance business. That's the MCI case. It's been applied to new emissions controls for existing coal mines. So that's West Virginia. It's been applied, the eviction moratorium at issue in the Alabama Association of Realtors case was one affecting 6 to 17 million tenants with a potential economic impact of $50 billion. And let me just pause on that for a moment because there's been some math thrown around.
There's a lot of math.
There's a lot of math. This is not a math question.
Yes.
And none of the cases treat this as a math question or as a question of fixed numbers. It gives a flavor of the significance of the agency's, the impact of the agency's action. Chair Gensler himself, the very day he made the request of Congress for authority to assert regulatory authority over crypto exchanges, prefaced his comments by saying this is a $2 trillion industry. The FCC's complaint, I think paragraph 1, talks about billions of dollars in trades happening every day. The economic impact here could be really crippling. And I want to just make a point that hasn't gotten a lot of play here today yet, which is the architecture that the SEC has in place. It does not work with crypto. That's why my clients made a pitch for rulemaking. There is no pathway to registration as it stands right now. So if the SEC's position is accepted, the potential impact of that is potentially crippling. On the other hand, if the SEC...
Is it crippling, or are you about to tell me it's existential? Or is it existential for those assets as to which transactions in the assets, however they come about, are investment contracts?
I think it is certainly, the impact is vast, Your Honor, and I will return again to the point that the SEC is offering no limiting principle, really, to what it will designate as an investment contract in the absence of a ongoing contractual obligation or something that's conferring a share in the enterprise. So the potential impact is vast. Now, it could go, I suppose, a different way. The SEC could put in place an entire new architecture that would address this. That's the kind of change, though, that the major questions doctrine says should not be effectuated by the agency. That's something that Congress should decide. Those are the kinds of questions that Congress has before it now, and that Congress should have been left to decide before the SEC came and took matters in its own hands.
But in fairness, they haven't done anything. So I am a little bit concerned. I have a concern about not recognizing someone's authority to do something in this space. The answer may be that I'm just out of luck until Congress acts, as you would say Chair Gensler recognized some time ago. But all right, maybe I'll just leave it at that. Okay, thank you. Did I just deprive you of some great thought you wanted me to know about?
Don't believe so, Your Honor, but I'm sure there will be an opportunity later if something comes to mind that I think I missed.
Funny you should mention that. We've now finished our 4th hour of argument, and I congratulate those of you who've stayed and listened through all of this. I have asked the 14 pages of questions I wanted to ask, and I thank you very much.
Summary arguments coming up.
I imagine that if I asked you, you would not forego the opportunity to say something to me in the vein of a summation. Or something I didn't know, something I need to focus on, or something I was too dumb to ask you about. So we're going to take another break, and I'm going to ask folks to get together. Mr. Pekin, my thought was that's where you would be coming in and you'd be speaking to that issue. But if there's something else, then tell me now, because you were designated cleanup. So what is it
I was responsible for correcting errors.
I see.
None were made. There was nothing for me to contribute.
I do appreciate the love, the back to the house of each other. I still think you should make a play to speak, but that's just me.
So, you know, Your Honor, this is the longest I've been silent for in my entire life.
I'm not going to disagree. Yeah. Okay, so take 10 minutes, think small thoughts, just something really summary that you want me to know that I'm not going to get from our argument, which I promise you I will reread the transcript of, and from the briefing, and just in case there's something we didn't cover and we should have, that's your opportunity. It should not, let's say 5-10 minutes maximum. This is not, the 2-hour summation at a trial. But take the break. Thank you all very, very much for your preparation. And my thanks to both to those of you who've spoken today, to those of you on quality control, and to those of you who actually prepared the oralist to speak as well as they did. You have my deepest thanks, because you should know this is a hard question, but I can't say there's an argument you haven't made to me. I just have to decide which one makes more sense. So we'll be back in 10, and thank you very much.
Woo! I think she may have actually done a 10-minute break, so let's put that 10-minute break back at approximately 11:32 California time with summary arguments. Okay, I'm going to go through and give a summary now. That's what I like to do. That's my job. I think it's my job, at least. I don't know. Hopefully that's my job. I like it. I like my job. All right, so let's do some summary arguments here. Oh, boy. And of course, we're going to summarize the whole thing, but I want to hear their summary, and then we'll do like a real full summary. So this will be sort of like a practice full summary. How does that sound? Okay, whatever. So let's get into it. So on ehack.com, I've kind of like written notes for the entire case, okay? So far, like at least what we heard today over the last 4 hours. So the whole 4 hours are summarized on ehack.com. But just to give you sort of my gist so far, the SEC is losing this one. I actually wrote on ehack.com, quote, "The SEC needs a better link between investing in a token and the expectation of profit in a project, in developers, etc. If the SEC can link that the benefits of development move with the asset, the SEC will have a stronger case." So, if I'm the SEC right now, okay, I'm sitting back there, I'm reading ehack.com, and I'm going, shit. We got a problem. Okay? So okay. If I'm the SEC, I'm going, all right, the strongest argument that we can make to argue that tokens are a security is that people invest in the tokens to invest in the common enterprise of other individuals, developers, the metaverse, apps, whatever it is. And because people are investing their money into that, and the representation of that investment via a token flows through the entire economy, the ecosystem, whatever it is, because the tokens are fungible, essentially. It's exactly the same, but you have sort of your share of ownership. Then you could argue that as the developers do a better job, the token goes up in value, and therefore you're benefiting from the profits of others. I think the SEC needs to make a very clear argument and go, in my opinion, all they have to say is, look, a stock, like if there are 100 shares in a company, and a company has, and somebody has one share of those 100 shares in a company, they own 1% of the company. So they get 1% of the profits. Well, how is that similar to a token? Well, with a token or whatever, you have 1 out of 100 shares. Maybe you have voting rights because of that. Maybe if you get to 2/3, you could take control of the whole enterprise, kind of like a hostile takeover, right? Those are the comparisons that I would be making if I'm the SEC, okay? So if I wanted to be the SEC, I would make very, very clear comparisons between how a token is just a slice of the ecosystem, and therefore anybody who holds that slice is a beneficiary of that slice. With, if they get enough slices, they have control, okay? That's an argument. I'm not saying that's the best argument. I'm just saying that would be an argument, okay? So then if you're Coinbase, honestly, you don't have to say much more, okay? Like, Coinbase is winning. Coinbase is absolutely crushing it here. Mostly because, quite frankly, well, some of the attorneys have done really good at Coinbase. The first attorney wasn't the best. The judge was basically handing Coinbase arguments. The judge is basically like, hey, there's no contract here, right? And if there's no contract, it can't be a security, right? And if there's no contract, then somebody can't sue for fraud. If, let's say, Solana goes bankrupt, can somebody sue for fraud? Now, Coinbase screwed up at one point. Coinbase is like, yeah. If the project goes bankrupt, then they can sue. And the judge is like, bro, I just fed you an argument and you just flipped it on me. What basis would they have to sue? Is there a contract? Oh, you're right, Your Honor. There's no contract. So I guess they would have no basis to sue. And the judge is kind of like, that's what I thought. So the judge here was really, really on the side of Coinbase the entire time. It was pretty obvious. And I was surprised that even when the judge was listening to the SEC's arguments, the judge really wasn't diving into the common enterprise or to be derived from the efforts of others part. There were a lot of questions about other things. Very, very brief touches on, rescission and the potential to sue. We talked about Bitcoin not being a security, how the judge said, why? Because it's a potentially a replacement for fiat, or more like a commodity. And then, of course, we had, the Beanie Baby argument. So the Beanie Baby argument was very interesting. The Beanie Baby argument was this idea of, hey, well, if you call tokens a security, then Beanie Babies might be a security, or baseball cards might be a security, or the judge even said this, fantasy football teams might be a security. So basically anything you put your money into and speculate becomes a security if you say that tokens are a security. And the judge here seems to be siding with the idea that maybe crypto's just its own thing. Maybe we need the Crypto Enforcement Commission, right? As opposed to the I guess it's Securities and Exchange Commission. But anyway, you get it, okay? So like, whatever, some other organization to regulate this new sort of thing. Like maybe there's a collectibles organization, like there are rating companies for rating cards, and there's a commodities commission, there's a securities commission, maybe we need a crypto commission, right? And it needs to be something totally separate. And so the judge is really worried about giving Coinbase too much power here. So if I do... again, we have a summary of issues so far on ehack.com, but I'm going to put an additional summary of issues for the SEC so far. And I would say that these are some of the new items that came up. Just while we're finishing up the break here, we'll go through some of these. Additional issues for the SEC would be the overbroad risk of calling everything a security. If you call tokens a security, do you also call Beanie Babies and fantasy football and, and trading cards, basically? Okay, there we go. And trading cards a security. Again, I want to be clear that the SEC should argue, IMO, this is my opinion, right? The SEC should argue a very clear comparison between owning 1/100th of a company and owning 1/100th of a, say like crypto asset or like an ecosystem, right? And then compare that to owning 67 out of 100, so like 2/3 of that company or ecosystem, and what kind of control that would or could bestow. Now, we know that every, crypto asset is different, and there are different rules, and so on and so forth. But that's the comparison that I would make, again, if I'm the SEC. If I'm the SEC, I'm trying, like, if you're the SEC, you should be trying to make this perfectly look like a stock, right? So everything that a stock does, you should compare. Coinbase counters this, though, and they're like, well, the difference, though, is... and this is the strong Coinbase counter. I'm going to write that down. Strong Coinbase counter, though. So the strong Coinbase counter is, well, with a stock and a bond, your ownership rights include rights to dividends, lawsuits, and they basically represent a contract. However, in a token doesn't necessarily represent your right to dividends, profits, or the right to sue. Bestow. There we go. Okay. So that's a really interesting counter argument from Coinbase, is that, well, I mean, just because you hold some Solana, you know, like, they don't know who you are. There's no cap table, right? They're just a bunch of wallet addresses. And see, that's another strong argument in my opinion. There's no cap table. You just have a bunch of wallet addresses. Okay, but are wallet addresses people who get rights? You see what I'm saying? So that's like, it's complicated, but it's kind of an interesting idea, because it's like, yeah, I mean, if I hold a stock, or a share of a company, I'm a shareholder of record. There's a transfer agent that documents my ownership in the company, and that ownership gives me the right to sue, to vote in elections, potentially if you have voting rights, to receive dividends, to receive assets in liquidation, right? That's another one. No, they're not back yet. You are right, it's 32, but they're not back yet. So I will just write, they'll be back shortly. Do tokens give rights in liquidation like shareholders of record? No. All right, that's actually a really good counter argument to the argument that I made about the SEC. I feel like I'm debating myself. Waiting for break to end. Judge summary arguments about to start. Full Kevin summary at ehack.com. Is this a Coinbase win? Yes or no? Yes, this is a Coinbase win, in my opinion. Like, so far, this is a slam dunk Coinbase win. I would be shocked if Coinbase did not win after what I've heard. And honestly, I was not expecting to say that. Okay? I thought I was going to hear some really good arguments from the SEC. I got convinced listening to these arguments that I think the SEC lost. So right here, in the last 4 hours and 20 minutes, how perfect, I got convinced that the SEC is right here. That's my opinion, okay? We're about to get summary arguments, so we'll see. But yeah, I guess I was a little surprised. I thought this would have been a lot harder of a case. Like, honestly, I was expecting this to be a little harder. Yeah, I don't know if we're gonna get any kind of decision today. I would say probably not, but it's possible. Okay, so I'm not gonna rule out the chance. Oh, they're coming back. What is eHack? Just go to ehack.com and figure it out. It's just where I put my research. I want to put all of my research on there. I haven't been really good about putting all of it there yet, but I've been putting as much as I can on there. And I think it's a really good database for you, and just to kind of stay up to date with the news. I like to think of it every time, and we're still waiting for the judge to get back. Every time you go to the pooper, go to ehack.com, okay? Don't go on Twitter, don't go on, I don't know, TikTok. Go to ehack.com, and then you could just get caught up really quickly, So when you next time you look at the porcelain goddess, I just want you to imagine somebody put a sticker there, and it says ehack.com.
Unless, of course, you want to forego all of this, which is also fine. Okay, thank you, Mr. Guerrero.
Thank you, Your Honor. And I am going to use some of the 5 to 10 precious minutes you've given me, not on summation, but on clarifying something that I think is critical to the court's decision today. There's been a lot of talk about Ripple, Terraform, and Library, and I know the court's going to look at the cases and the briefs. So, in one respect, we absolutely agree with the court that this case is different, and the reason it's different is because in this case, we sued the intermediary. So the cause of action is here, Section 5 under the 34 Act. In those cases, all of them involved, at a minimum, causes of action under Section 5 of the 33 Act. But what those cases did involve, and I think there's been a perhaps accidental misstatement, particularly of Terraform, is sales by those issuers on these, what we're calling today secondary market platforms. And to read from Judge Rakoff's summary judgment ruling, and that's page 16, I think, of the Westlaw version at least, and it's in a section where he says that Terraform violating Section 5, Terraform also sold both Luna and MIR tokens to secondary market purchasers on ... crypto trading exchanges. So our contention is, if he's correct that those were securities, and these crypto trading exchanges meet the statutory definition of exchanges, those exchanges are violating, like Coinbase, Section 5 of the 34 Act, while Terraform is violating Section 5 of the 33 Act. Neither Ripple nor Terraform nor Library involved any claim by the Commission that a sale between, what I'll say, two of us here at this table was a violation of the Act. All of those cases focused entirely on the issuer's conduct, but all of those cases, Ripple included and Library, all of them, they sold also on these platforms, right? And Judge Barbaduro found no meaningful distinction, neither did Judge Rakoff and Terraform find any meaningful distinction between an issuer selling on the platform in what Judge Torres calls blind bid-ask transactions, or selling them more or less directly through these, one-on-one meetings. And the reason that matters to us, Your Honor, is because, the cases are different in the cause of action. Our perspective is they're identical in terms of the Howey test that applies. And we think Coinbase is trying to create a different Howey test for when the people at this table might sell the tokens to each other on its platform, and when Terraform might sell its tokens on Coinbase's platform. And we think that's just wrong, Your Honor. And actually, Coinbase did the court a favor, put some of our briefs there, and if the court does in its spare time look at the briefs, our briefs and the defendant's briefs, they're actually remarkably quite similar. A lot of them talk about these contractual obligations. And so our perspective is it's the same test. The fact that it's an issuer selling it on the platform, or that two people are reselling it amongst themselves, does not materially alter the outcome. And why does this even matter for this case is that there was a lot of conversation about the asset hub, but the key sentence in paragraph 65 of our complaint, Your Honor, is actually the last one, which Coinbase, I believe, admits, or at least qualifies. And what we say there is that Coinbase does not restrict issuers from selling its tokens on these platforms. And they admit that Coinbase permits them, subject to certain restrictions, to create customer accounts and engage in secondary transactions. So if Judge Rakoff is correct, then that's the end of this motion to dismiss, given that admission in paragraph 65. Now, to be fair, to be clear, we focused it on sort of the Solana and these tokens because, again, we don't view a distinction between the issuer selling, or what Coinbase calls engaging in secondary market transactions on the Coinbase platform. That's a reference to the exchange, not Asset Hub. And again, people at this table selling amongst themselves. So that's the clarifying point. I'll now move into a brief summation of the court's indulgence. So the parties agree,
very weak,
I think,
very
Your
weak.
Honor, that this case is resolved by the statute, and really it's not a major questions case. There's some modicum of agreement. Where we part ways with Coinbase, at least for purposes of this summation, is as to what Howey requires. We think they're making up a new test, and we believe that our position is the one that's most faithful and consistent, but in fact compelled by the Howey test. It's not just a plausible reading as they claim it is. And one phrase I would like to leave the court with that was not discussed a lot today, that I would like to have in the court's mind before we leave, is economic reality. Economic reality is part of the analysis that Mr. Costello was offering earlier, and that I believe is completely devoid from Coinbase's arguments, and that provides part of the limiting principle, including the court's concern about a floodgate of private actions. And so I'd like to borrow from a rhetorical question that the Chief Justice asked in the Biden versus Nebraska case. Would the Congress that enacted this regulatory structure be surprised that the Commission is bringing this action? We know they created the Commission. We know they created We know they said to securities exchanges, you've got to register. We know they gave the commission the power to sue if someone violated this command. So the answer to whether they would be surprised, and Coinbase, we know, does not dispute for purposes of this motion that they are an exchange. The answer to the question depends on what are they exchanging? Coinbase and the Amici suggest that we're suing the supermarket, that we've sued Whole Foods. And I concede that if we have sued Whole Foods, we should lose. But economic reality makes it quite plain that our lawsuit and these transactions and these assets are of a quite different nature than if I were suing someone for intermediary transactions in bananas or other items that they've used in their examples. What is at issue here, and let's just imagine this in the eyes of the Congress of 1934, it's an exchange. That's conceded for purposes of this motion. The exchange permits buyers and sellers, they get together, and they trade in these assets. What are these assets? It's a matter of economic reality. There are issuers also in this marketplace, and these issuers are saying, and in 1934 there's no crypto, so what they have maybe is just a piece of paper with numbers to keep track. That's all that is, and that doesn't do anything. It represents what these investors are buying. And the issuers say, give us all your capital. Give us your capital. We're going to take this capital, and with this capital, we're going to make these little pieces of papers with numbers valuable. And you'll be able to resell them, and you'll make some money. And the exchange, again, the conceded exchange, also permits people to buy and sell amongst themselves these same little pieces of paper. And everybody knows, because these issuers in 1934 have flooded all the then available methods of communication. And they've bought radio ads, they've put it in the paper, and they've sent glossy mailers, and they've said, this is what we're going to do. Because I have to explain to you what these little pieces of paper do. They're not bananas. Let me explain to you what's going to happen with them after I take your funds and deploy those funds into this ecosystem. You're going to make some money. And the other thing the issuers remind everyone of consistently is, and I'm going to keep a big stash to myself, because when they go up in value, I'm going to make money too. So the reasonable investor in 1934 understands that what they're buying into is an investment contract. Would the Congress of 1934 be surprised that we've asked that this exchange register? I submit to the court that the answer is plainly no. If the response were, well, yes, you're right, SEC, but the issuers were clever enough, and not to use a magical word like impressions of an offer of contractual obligation, or were clever enough to not reduce into writing the promises that they've made, therefore this is Whole Foods, I submit to the court that the Congress of 1934 would not only be surprised, but actually stunned that there would be such an easy workaround to the carefully constructed regulatory structure that they created in 1933 and 1934 around the capital markets. So we are asking that the court not endorse such an outcome, Your Honor. We are simply asking that the court look at the economic reality, apply the Howey test as it was written, and to end on a major questions point, we believe that the Howey test is there precisely, as I said, to give effect to that congressional purpose, and to set it aside or add elements to it as Coinbase is really asking the court to do is what really would create violence to the statutory structure. For those reasons, Your Honor, we ask that Coinbase's motion be denied in its entirety. Thank you.
Thank you very much. Just one moment, please.
Kind of really dodged the idea about an investment contract being missing. He suggested, like, oh, well, they tried to write around it or whatever. That's not the strongest argument.
Thank you. Someone at the back table.
Your Honor, good afternoon, and I think I've been designated to...
Congratulations.
Thank you so much, and let me say that we're grateful for all the court's time and patience with our arguments.
Not at all. Thank you. No, you've helped me more than I've helped you in any way, but thank you.
Thank you, Your Honor. And let me start here. I think after all of it, after our 4.5 hours, and after hearing from our friends at the table in front, the SEC still has not alleged and doesn't contest, doesn't argue that the issuer of any of the 12 tokens that it challenges in this complaint made any statement that could be interpreted as a contractual obligation, still less any kind of promise or obligation that traveled with any of the 12 tokens at issue when they were sold. blind transactions on the secondary market. We heard a little more about paragraph 65 of the complaint, and I don't want there to be any confusion on that. That paragraph allows that promoters, like everyone else, can make trades on the platform of tokens that have already been issued. It does not involve primary transactions. It is purely secondary transactions. That's what paragraph 65's last sentence is about, and for the reasons we've talked about, nothing in the allegation of this complaint gives rise to any allegation regarding any primary transaction or initial coin offering. And the fact that there are no promises of any kind that travel in any of these transactions, we think is fatal to the complaint. I want to talk just a bit more about Howey, because it's an important case. And I don't know if it's the alpha and the omega. I don't know if it's the beginning and the end, but I don't think there's any mistake about it. Howey is where we start. And the promoter there, just talking about economic reality, the promoter there was a company. It sold parcels of land and a commitment to do stuff on that land, 2 contracts. The question before the court was whether those 2 contracts can be stapled together. If the answer was yes, there would be an investment contract. If the answer was no, there wouldn't be. An asset plus an obligation. That is what all the blue sky law said an investment contract was. That's what Howey said it was. Now, the commission has argued in its papers, and we didn't get a chance to talk about this when we were talking earlier, that Howey's obligation to develop the orange business was what it called purely incidental. It does this, the commission does, by plucking those words purely incidental, rather obviously out of context in Howey itself. The sale of the land, the asset sale, was what the court called purely incidental. The management contract, the contractual obligation to develop the business, that was the opposite of incidental. It's what made the arrangement a security. There's no way to read that opinion and not understand it. You can even read Justice Frankfurter's very short and completely overlooked dissent, and it'll tell you the same thing. There is no doubt that what made the 2 contracts there, an investment contract, was that the asset was stapled to an obligation to manage. The cases, one after another, teach the same lesson. I won't rehearse them all. I will also refrain from undue counterfactual historiography as to the question of what the congressmen and women of 1933 and 34 would have thought about this, but I'll tell you this. I think there would have been a lot of surprise to find that an investment contract didn't have anything to do with a contract at all. And that is the position that's being sponsored here, that the very words of that statute are being erased from it, completely in derogation with all the case law that preceded it and all that has followed. I'll also say, I think it would come as a surprise to Senator Loomis that this was obviously something that was to be regulated. I won't cause the court to look at it, but slide 12 recounts about, I don't know, maybe 12.5 statutory initiatives over the past 2 years where Congress is trying to figure out who crypto should be regulated by and how. I think there's an awful lot of surprise, historical and present, about the willy-nilly arrogation of regulatory authority that the SEC purports to assert by virtue of this action. Part of the trouble with the position the commission here sponsors is that we wish to insist that there has been no showing of a necessary limiting principle. We talked about this a little bit, Your Honor. I want to push on it because it won't do to say an asset plus promotional statements is enough. And it won't solve that problem to say, well, you're buying into an ecosystem. I am advised that there is an Apple Plus documentary about Beanie Babies that talks at great length about the community.
Don't make me watch it.
Your Honor, I thought about it. That makes perfectly clear the communities that grew up around that. And it is true of all sorts of things that people buy and sell. The buying into a community. It is an absolutely vacant limiting principle. It's no limiting principle at all. The point is further illustrated by the acknowledgement, the concession that Bitcoin is a commodity, not a security. Bitcoin has every bit
the ecosystem of these other tokens. There are community groups, there are
Whoa.
chat groups, there are validators, there are support groups. Bitcoin is an ecosystem just like all of the others. And that won't do as a limiting principle as the Commission's own actions, we think, make clear. On the other branch of our argument, whether the investment needs to be in an enterprise, I just want to make sure to call to the court's attention what Howey said. Because Howey didn't use the idea that the investment contract had to be what they called shares in an enterprise idly. That's from the Supreme Court, 328 U.S. at 299. That's Howey. And it's not for nothing that Judge Boudin talked about in finding and discussing investment contracts that what was purchased in this case was not a share of a business enterprise, and so not a security. These cases haven't addressed this issue, because this issue is new, but they address the principle at issue here, which is when does an investment in an asset become an investment in an enterprise? And the answer is clear in case after case. It is at the moment where the asset is stapled to a contractual undertaking that gives an interest in the enterprise. Let me close with just a word or two more on secondary markets, because I think the following can be fairly said. The Commission's complaint draws the court into truly unprecedented territory. To call these secondary market transactions investment contracts when there's no contract is atextual, and it's ahistorical, and it's unprecedented. There has been no finding of any kind, any court, that a transaction on the secondary market gives rise to an investment contract, and that is not a coincidence. Echoing the conversation, Your Honor, that you and I had a little bit ago, investment contracts, well, they're contracts after all, and that implies privity. And absent unusual circumstances that haven't eventuated in the decided cases, circumstances that one could imagine, but nevertheless aren't alleged here, contractual obligations could travel so as to create an investment contract. No allegation here. And what we say you can't have, what we say would make a hash of the statute, is an investment contract without at least the appearance of an offering. And that is completely not alleged in this case. And there was reference...
May I hear that again, please? You cannot have an investment contract without at least the appearance of an offering?
You can't have an investment contract without at least the appearance of an offering of an instrument that carries with it the contractual obligation.
Thank you.
While we're talking, no, absolutely.
What do you mean by appearance of? At least the appearance of? It's this strange simulacrum that you're suggesting. I want to know I guess you're just trying to cover all bases. I just want to know what that means. It's the word appearance that's thrown out.
And it's fair enough. And what we're trying to convey here, Your Honor, is an attitude towards this instrument that is not ungenerous, but generous towards the Commission. If there is an instrument that is meant to convey a contractual obligation, that is an offering of an instrument that is meant to convey that will satisfy the securities laws. But it has to partake in the appearance or offering or intent to create a contractual obligation. Otherwise, you do not have an investment contract. You just have an investment. So it's got to be stapled to something that, from an objective standard, could constitute the offering of a contract in the mind of a reasonable offer and offering. I wanted to very quickly just mention the Dow report, because it came up earlier, and it bears a little bit on this, because it's the kind of instrument that one can imagine fulfilling some of the characteristics that aren't fulfilled in the pleadings. But what I wouldn't want left is the impression that the Dow report put anyone on notice of what was going on here. Here's what the Dow report said. The Dow token was like, and I'm quoting now, buying shares from the SEC. The token was like buying shares in a company and getting dividends because token holders could vote to distribute the Dow's anticipated earnings from the projects it funded. That was the Commission's conception in 2017. Notice its language. It has all the earmarks, not just of what we're saying today. And of course, we're litigants, so you'll be skeptical of us. We have a position. It has all the hallmarks of all the cases have been saying for 100 years.
2017, you had an instrument that was buying shares, that had the possibility of getting dividends, that had voting rights, and therefore had an interest in the enterprise in a manner that at least resembled other securities. That's what the Dow report was about. And we're 180 degrees away from that point now. In fact, no court has ever held that something without those sorts of attributes can be traded on a secondary platform and be a security. Finally, I want to say this, and then I'll stop. Coinbase appreciates the utility and the wisdom of sound and predictable regulation in the crypto industry as in elsewhere. The court should know that Coinbase is subject to many regulatory regimes, state regulatory regimes, the CFTC. It's not as though there is no regulator with any authority beyond the SEC. And Coinbase has made clear in this case, in its public statements about the SEC, that it's looking for rules of the road. And we know the SEC has a broad mandate to regulate things that are securities. But the SEC's regulatory reach does not go beyond securities. And if it's permitted to regulate here, it's permitted to regulate everywhere. And it could do so in after-the-fact enforcement actions, with or without notice, with or without warning. And that is not the way administrative law is supposed to work. The SEC knows, Your Honor, that it's trying to squeeze crypto transactions into a statutory rubric where they don't belong. That's the significance of the Chair Gensler remarks. That's the significance of the Hinman report. That's the significance of Dow. There's an understanding that they don't fit. We know Congress is trying to sort it out. And what should happen here is the SEC should follow enforcement and rulemaking actions that make sense of the statutory language, that does not twist it upside down, that does not read the word contract out of the word contract, that harmonizes rather than does violence to all of the cases that have come before it. And this is several bridges too far. And for that reason, we really urge the court to grant the motion.
Wow. Strong.
Earlier today, my deputy said to me with some horror, "Are you going to decide this from the bench?" And then it only prompted horror on my part because no, I was clearly not. I had questions when I began this day. I have some answers, and I have some questions as I end the day. So I suppose I should thank you both, and it is a measure of everyone's preparation that I can't decide this from the bench right now. So take that as the compliment it is. I have a favor to ask of the folks at the back table, and that is if you would please, if you would accept a friendly amendment of your transcript order to be tomorrow rather than this evening, because I'm aware that the court reporters have been moved to other places this afternoon, and I kept them so much longer than they thought, that I just ask for your indulgence. Again, since I'm not deciding today, and with appropriate respect to your client, tomorrow should be fine for everybody, so I'm going to ask that
All right, we're going to do a summary. Let's do a full summary on this. I'll give you the decision. The case is over. It's not going to be decided now, so we can disconnect on this. Let's do a full summary. So if you've got like 8 minutes, let's go ahead and let's just go through everything. So if you're just now catching up, I'm going to record this. I'm going to post this on the main channel, okay? I look like crap because I've been sitting here for 4 freaking hours. Whatever. Okay, let's go through this is a lot, okay? So I'm gonna do my best, and I'm gonna give you my opinion as to who won this case. Should be obvious already, but I'm gonna give a full and neutral and unbiased summary. So here we go. Let me lower this a little bit because it's annoying. There we go. All right, make sure that's rolling. Yep. All right, we're good. There we go. Wow, I went into the SEC versus Coinbase lawsuit hearing today, January 17th, 2024, honestly expecting that the SEC would come prepared with an incredible argument for why the 12 tokens that they listed were a security. And Coinbase, I thought, was going to have a hard time defending against that. In this video, I'm going to give you my opinion in terms of who won this case. Right now, the motion at hand, the decision at hand for the judge is whether or not to let the case continue or to dismiss the case, to decide the case based on the pleadings thus far or to throw the case out. The judge has indicated she is going to wait to make a decision, and she is not going to rule at the moment. So, without the judge ruling at the moment, we are going to go through some of the summaries and some of the big cases here, and we are going to come up with a conclusion. I want to be clear. I personally think the judge already has her decision. I just think she needs to structure her decision properly. I think she was sitting there listening, writing her decision. And so I think this case is already decided. I am 90% certain which way this case is going to go, though I could be totally wrong. I'm just a neutral person who looked in from the outside going, okay, I think the SEC is going to get rolled here, and let's just say I was surprised. So, what happened? Okay, here's the gist of what happened. I'm going to give you the summaries and we'll go into some more details. First, there were multiple cases where the judge argues, what makes crypto not its own thing? Why is it a security? And the SEC argues, well, there's this thing called the Howey test. Okay, the Howey test comes from a lawsuit, the SEC versus Howey Co. Okay, and there are 4 components to the Howey test. The Howey test makes it clear that something is a security when you provide an investment of money in a common enterprise with the expectation of profit to be derived from the efforts of others. But there are 2 parts of this that are a little complicating. One, there's the actual Howey test as to whether or not something is a security. And then you have to evaluate, well, is it a primary transaction we're talking about or a secondary transaction we're talking about? So I don't want to lose you. I want to make this as simple as possible. If Apple comes to you and says, yo, or let's do a different example. Elon Musk comes to you and says, I'm going to sell you shares of SpaceX, and I own SpaceX, right? And he is SpaceX. He's representing SpaceX in this case. So SpaceX goes directly to you and says, here are shares of SpaceX. Well, that is a primary issuer transaction, which is regulated by the SEC. Now, let's say you own Coinbase shares. Or SpaceX shares, and they're this laptop or whatever, right? This laptop represents those SpaceX shares. And I meet you in an alley somewhere, and you're like, yo, I want to sell you some SpaceX shares. You want my SpaceX shares? I'm like, sure. I'll give you this handgun for them, or these donuts, or money, whatever, right? And you're like, deal. And we shake hands, and we exchange the shares for some exchange of value. That could still be a security. This is still potentially a security. But that's considered a secondary transaction, which is an exempt transaction from the purview of the SEC. Like the SEC isn't in the alley policing you going, up, you need to follow the rules. That's really important because Coinbase is making this argument that, whoa. First of all, even if it is a security, we're just dealing in secondary transactions because different people's wallets are connecting. And different people's wallets connecting are not us representing an issuer like SpaceX and helping them sell shares. Different people's wallets connecting has nothing to do with us and the issuer. That's one of the arguments that Coinbase makes. The second argument that Coinbase makes is that the Howey test, and all of this is summarized on ehack.com, by the way. Go to ehack.com. It's totally free. I post a lot of my research there and commentary on there. But anyway, it's my website. I write it, okay? So anyway, and again, it's totally free. It's going to be free forever. So the Howey test has a lot to do with investment contracts. Now, how do we know that? Okay. Well, that's really simple. So all you have to do is Google SEC versus Howey and Howey Co., the Howey company, okay? And when you Google that, you could find the actual case law. This is an old 1946 case law. And what's really important in this is the phrase investment contract. Upon the facts of the case, an offering of units in a Citrus Grove development, coupled with a contract for cultivating that grove, was an investment contract within the meaning of the 1933 Securities Act. Okay, interesting. So that is where Coinbase's strongest argument comes from. Wait a second. Even if something is an investment of money into a common enterprise with the expectation of profit to be derived from the benefit of others, wait a second. Is there a stapled investment contract to that. For example, when you buy a share of Apple, you have your name put on a cap table somewhere. A transfer agent says, okay, Kevin Smith or whatever, you now own these shares of Apple. And as a result of that, you have potentially the right to vote, the right to dividends, the right in liquidation of the company in the event the company liquidates. You have the right to residual assets. You have the right to sue. You have a lot of rights that come with your ownership in that company. Coinbase makes the argument that the tokens that Coinbase threw in their lawsuit, which I have a screenshot, by the way, of the tokens that they threw in their lawsuit. I believe these are the 12 right here. Cardano, CHZ rather, Solana, Axie, Infinity, Filecoin, Internet Community, Computer, I'm reading this too fast, Flow, Near Protocol, Polygon, Voyager, Token, Sandbox, Dash. Anyway, all this is at ehack.com. Anyway, point is, they're arguing that none of those come with an investment contract. Now, the SEC makes the argument that, wait a sec, there is a reasonable expectation of profit from investing in these coins or tokens or whatever you want to call them, right? And of course, that depends on the way they're structured, whether on Ethereum and so on. We don't have to get into all that. But the point is, the judge gave a really big tell right here. Here's a really big tell. I want you to see this one. The judge says, so if you find these are unregistered securities, wouldn't the asset purchasers have the right of rescission? And then the SEC goes, yeah, that's correct. Okay, that would imply that there's an investment contract. The judge trapped the SEC there. The judge literally smacked them upside the face with that one. She walked them into a landmine on that question. She's like, hey, if these are indeed securities, just what, like think about it. I want you to think about this, okay? So I'm the judge. Hey, SEC, so these are securities, right? You think these are securities? Yeah, we think they're securities. Okay. So in that case, there would be a right of rescission, right? Because securities have a right of rescission, like the right to cancel your investment due to fraud or whatever, right? Yes, that's correct. Okay, that's what I thought. And then the judge is processing in her head, but these tokens don't have a right of rescission. See? The judge totally walked them into a landmine on that one. And they bit that one hook, line, and sinker. So that was a big deal. Remember, a rescission is a cancellation of the contract. Again, I even wrote that on eHack. This is a big deal. So the judge walked them into a landmine on that one. What else do we have? So the SEC argues, well, it's part of an enterprise. They've argued this over and over again. And they basically say, but look, the SEC's argument is, come on. It's a token. There are a group of developers. And when the developers with their biographies and their skill sets, when they make the metaverse better, or they make the underlying applications better, when they make the ecosystem better, then when that ecosystem gets better, the value of the token goes up. Okay, that may be true. But does that bestow contract rights? That's the big burn on the SEC. Now, the SEC should have, in their summary arguments, which I wrote on ehack.com, I wrote, the SEC should have made a very, very clear link between a token and the expectation of profit in a project from developers by linking the benefits with the asset. They needed to show that. In fact, I go as far as saying the SEC should make a very clear argument that if you own, 67% of a token ecosystem, maybe that gives you some control in a certain token ecosystem, right? Maybe that lets you manipulate it or change the voting or whatever, depending on which we're talking about. The SEC punted on that. They did not make that argument. That was probably their best argument. They didn't even make their best argument. Okay, no problem. So what happened when the judge was talking to Coinbase? Well, again, they made it very clear that there is no stapled contract to a token that says you have the right to liquidation, you have the right to dividends, you have the right to anything beyond your speculative interest in that token. And the judge frequently said, so it's kind of like if my friend owns a football jersey and I want to buy that fantasy football team because my friend owns that football jersey, am I investing in a security? And the judge is basically rhetorically arguing, just because I put money into something with the expectation of making money does not mean it's a security. Because if that were true, I wouldn't invest in trading cards, I wouldn't invest in Beanie Babies. Basically, all collectibles would be securities, all commodities would be securities. And the judge literally says, whoa, we're getting way too broad here about what a security potentially could be. So now Coinbase then goes on to say, look, like all we do is provide services. Yeah, we're an exchange. Yeah, we're a broker dealer. And yeah, we provide wallet services. But wallet services are just like an internet browser. Like when you go on Google Chrome and then you go interact with Chase, are we somehow responsible for what you do with Chase because we helped you get on the internet? You know, is Google Chrome responsible for what you do on the internet? No. So why would Coinbase be responsible for helping you have a way to connect? That they're an IT service is what Coinbase's argument. That seemed to be a strong argument that somewhat resonated with the judge. Now, the other thing that I thought was really interesting is the judge responds when, so Coinbase says, so, you know, we thought the SEC would present a scheme of contracts claim. This is a big one. A scheme of contract claim suggests that there's an implication that there is a contract. Even after Coinbase said, hey, Coinbase, we thought you, or SEC, even after Coinbase said that the SEC might present that argument, the SEC did not pick up that argument, by the way. And what was really interesting is it kind of went like this. Coinbase goes, we thought the SEC would present a scheme of contracts claim. Again, the implication that there's an investment contract. And the judge goes, you weren't presented that. And Coinbase goes, exactly. It's almost like the judge was like bantering with them. That came at roughly the same time that Coinbase is like, we have slides as well. Can we show you our slides? And the judge literally says, I'd love to see your slides. I'm sure somebody stayed up through the night making those slides. She was full serious. She's like, bro, how much Coinbase stock do you own, lady? Like, it was so obvious the whole time. She was totally like handing this case to Coinbase. Now, Coinbase did F up once. They had one really big F up. They covered for it, but they had a big F up, okay? The Coinbase F up was simple. So, the judge goes, hey, so when you invest in this contract, or rather this token, what happens if Solana, let's say, goes belly up? What happens if Solana goes bankrupt and I invested in Solana? Would I have any rights to sue the developers of Solana? And then Coinbase replies and says, well, the purchaser of Solana would have a claim in fraud. And no, that was the wrong answer. Because the judge is like, wait, but you just said there's no contract, so how could there be a fraud claim? The judge literally handed them an easy win right there, and they totally fumbled on that. And then the Coinbase guy retracts, and he's like, I'm sorry, I mean, no, it's not fraud, it's tort. That's different. Yeah, you're right, there's no contract. And they kind of got back on the same page. But it was really interesting, even through that total disaster, the judge was still trying to like help them along. So I think the judge kind of went into today with a decision already made, and they were looking for a stronger case from the SEC. Now, I did think it was weird that the judge is literally like, hey, I've got senators telling me, don't get involved in Coinbase, like stay out of this. And the judge is like, so maybe I should just stay in my lane. And I'm like, wait a second, you're literally saying that you're being politically what? Okay, whatever. Maybe she's just being transparent, whatever. But then there was yet another argument, okay? And this was an interesting one, which was crazy because this is literally what the SEC used in their closing argument. I'm like, bro, why would you use your weakest claim in your closing argument, SEC? No. Like, I'm trying to look at this from a neutral point of view out of interest for like how law works and judges and the judicial system works. So the weakest argument the SEC had is literally what I'm about to say, which they ended up using in their summary argument. The SEC argued that Coinbase is an unregistered exchange and that the SEC has never approved a broker-dealer also operating an exchange. So think about that for a moment. There's the New York Stock Exchange and then there's Robinhood. They're separate, right? Coinbase is both. Coinbase is both the New York Stock Exchange and Robinhood. And the SEC is like, there's a conflict of interest between the broker-dealer also being an exchange. We've never approved one of those before. And you know what the judge says? Is that against the law? And the SEC responds, well, it's not illegal per se. We've just never approved an exchange that was also a broker-dealer. Bro, why would you use that argument in your closing argument? That was your worst argument. Oh, I mean, whatever. Like, it's good for the crypto community. I'm just saying, like, I was shocked by the SEC there. So the SEC also, and this was a really damning point, which is amazing for the crypto community, but this was a damning one, okay? The SEC goes, or the judge goes, well, I'm sure everybody buys tokens because they hope they appreciate in value, but that's why people buy trading cards or Beanie Babies as well. Are there tokens without an ecosystem? And the SEC goes, yes, Bitcoin. The judge says, is that because it's a replacement for fiat? No, there's no ecosystem behind it. If no one is inducing anything, you can't be buying a security, so to speak. And the judge says, basically, that like, hey, so is Bitcoin a security? And the SEC is like, well, no. Okay, now, what did Coinbase do? Coinbase literally took that admission in this case and at the end says, hey, Bitcoin actually isn't very different from all of these other tokens. There are support groups for Bitcoin, just like there are support groups for Cardano. What's the difference? And so Coinbase went like to the next level here, and they're like, hey, come to think about how much we're winning this case, what really is the difference between Bitcoin and all these other coins? After all, the SEC did say Bitcoin isn't a security, so maybe that's the argument. It was like, oh my gosh, it's just like putting the nails in the coffin. So anyway, that argument might not hold, but it doesn't need to, because well, let's put it this way. The strongest case that the SEC could have put forward, which would have been the connection that tokens are like a stock, the SEC did not make. Instead, Coinbase had the benefit of making the strongest argument, which is even if you're making an investment with the expectation of making a profit, there is no contract. And the Howey test, which is what this all relates to, has to do with the fact that there is an investment contract. Now, I will say, the judge did say, and this was a potential weak point, she said there could be a void in Coinbase's argument. The void in Coinbase's argument is that, wait a minute, does Howey actually only apply to investment contracts? Because remember, and this is something else that could be debated, okay? This could be debated. Remember, there are 4 components of the Howey test: an investment of money in a common enterprise with the expectation of profit to be derived from the benefit of others. Notice that none of those 4 things say investment contract, but all of those 4 components came from the Howey case, which defines that a security is any investment contract. So it's kind of like, can you take one part of the Howey case without taking the investment contract part? That could be debated. So if the judge, and I'll give you my opinion on this, if the judge wanted to side with the SEC, they could say, Howey test doesn't say investment contract, therefore SEC wins. That's all the judge would have to do. The Howey test nowhere says anything about there needing to be an investment contract. It's a security. But the problem with this, which is what the judge indicated, is, well, wait a minute. What if I invest in Beanie Babies? I expect to make money. I expect other people are going to be interested in Beanie Babies, which means I might benefit from the efforts of others. You know, maybe other people are going to burn Beanie Babies. There'll be less Beanie Babies out, kind of like people burn tokens. There'll be less Beanie Babies outstanding, and then the value of my Beanie Baby will go up, right? And then you could argue, well, is that a common enterprise? Like, you could make all of these different arguments, right? But the judge is really concerned that if she sides with the SEC, she encompasses commodities and Beanie Babies and trading cards all under the purview of a security. When the reality that the judge seems to point out is Coinbase is providing facilitating services. Coinbase is providing IT services. Coinbase is primarily operating in secondary transactions, which have no jurisdiction with the SEC. They're exempt transactions. And you can't look at the Howey test with just these 4 components. You must also consider the investment contract aspect. And since there is no investment contract in relation to these tokens that people are trading, then these tokens can't be a security. The reason for that is this idea that, well, like, who gets the contract? Can a blockchain address be a party to a contract? And I'm not talking smart contracts here. I'm talking about legal contract in law. Well, a wallet address isn't a legal entity, and it's not a person, it's an address. You know, it's like a P.O. box. It's like saying my P.O. box has the right to sue somebody. Well, no, it doesn't. So, do those tokens, which have ownership in random wallet addresses, like, who's the individual that actually owns those wallet addresses who would get contractual rights? So in other words, you can't really have a contract if you don't know who the other person is. But by virtue of the blockchain, most of the time you have no freaking idea who the other person is. So if you don't know who the other person is, how could you have a contract with the other person? Which means there can't be an investment contract. And if there can't be an investment contract, then the Howey test can't qualify, which means these are not securities. So now I'm going to give my bottom line opinion on this. My bottom line opinion on all of this, I think with a 90% degree of certainty, Coinbase wins this. I went into this thinking nearly the opposite. I've been convinced, after listening to this for 4.5 hours, the SEC did not make a very convincing argument. The judge seemed married to Coinbase. And quite frankly, the arguments over at Coinbase, despite their stumbles, one stumble, were strong. I think they made a very good point. So that's my opinion. You know, don't sue me, bro. I'm literally a dude with a Lego cup and the skull Lego cup over here who wants to drink coffee and go to the bathroom because it's been like 5 hours. So if you like this kind of content, make sure to subscribe to the channel. Check out ehack.com, and I'll continuously bring you news over there. The next thing I'm going to be posting over there is going to be the Beige Book, whenever I get around to dealing with the Beige Book. Thank you so much for watching. Really appreciate y'all, and we'll all see you in the next one. Goodbye, and good luck.